Someone make it make sense.
I'll be a couple.
Hello, how's everybody doing today? We are back for more with this incredible, spicy bond hearing where we've already learned a whole lot. I did want to make sure I pointed something out that for anyone who is new, or whether you're new or not, I do really detailed timestamps for every video, for every live stream. And the thing about YouTube is sometimes the timestamps appear and sometimes they don't. And sometimes they'll be there and sometimes they'll go away and then they'll come back. It is completely random. I have no idea. But what I wanted to say is for anyone who's watching or is catching up and going back through the playlist, this playlist or any of them, if you don't see timestamps appearing on the scrolly bar, they're in the video description. Always. So you can always utilize it that way. And again, typically they will at some point appear in the scrolly bar. I don't know why it works like that, but that's just what it does. So as for part one of the bond hearing, I am I think over halfway done with timestamps, maybe a little bit more, but again, they're not, last I checked, I didn't see them on the scrolly bar, but they're in the description, or maybe they're on the scrolly bar by now. That would be amazing if they were. Yes. Glad you're here. Merry almost Christmas to you also. Yeah, it's getting close, isn't it? That's crazy. Wow. So yeah, so we are back for, we finished last time with the state's only witness who was on the stand for a long time, Detective Johns. We had a really exciting cross-examination, to say the least. Again, it was like bombshell after bombshell. I don't know how else to describe it, but again, all those moments will be time-stamped. Some of them already are. So where we're picking up now is with the defense witness or witnesses. I'm not quite sure if they have, I think it's just one. But I also wanted to mention for anyone who's interested, I do have the Sarah Boone letter. I haven't even read through it or even watched anybody cover it yet, except for like a couple seconds. My understanding is that a lot of it is the same as what she read at her sentencing. And then there's like some addendums, if you will, or some additions. I guess it's the things that were cut out. So, but if anyone is interested, we can read that. We could read the whole thing, or we could read just the changes, but just let me know, because I have that. I mean, we would do it on a separate stream, but yeah. That's awesome that Christmas is your favorite holiday. Awesome. Yeah, I love Renaissance Christmas music because I'm a nerd. So, yeah. And what else? Okay. And then also the Dauber hearing for Karen Reed was today. I thought maybe it was moved because I was looking this morning and like all of the channels, no one had it scheduled. It was kind of odd, like NBC Boston. I mean, all the local news networks, like it wasn't, Court TV longer. It wasn't scheduled. So I was like, did they move it last minute? But it happened. And so I think I have that scheduled for Saturday. And then I believe I have Casey Anthony, the next episode, scheduled for tomorrow. And if anyone is interested in the Sarah Boone letter, I'll schedule that. I don't know if it'll be tomorrow or the next day, but we'll do like a back-to-back where it redirects or whatever. But you guys might have heard it enough to where you're like burned out on it. So, because I know like everybody I'm sure is covering it, right? Again, I haven't actually listened to any of it. Yeah, I haven't had time, but I would imagine for anyone who's been doing that, you probably have that letter memorized by now. The other thing too, if anyone is interested in going over the manifesto, Luigi Mangione's manifesto, I don't know. We can do that. I have some interesting thoughts on some of that, and also the Goodreads review, that it might be worth. So because you guys, if you've been here before, you know that I loved philosophy and I took philosophy in college. I almost double majored in philosophy, and I feel like there's a lot of nuance that's getting lost. But I feel like also there's a way you can kind of see the progression. Like in other words, I don't think it's fair. Okay. I don't think it's necessarily fair to write off somebody's ideas just because at some point they do something violent, right? Because that doesn't mean that the ideas in and of themselves prior to the violence or without the violent part, right? Like the ideas are all bad. Like, I feel like it's really easy to look at, same thing with Ted Ted Kaczynski, same thing like that, right? I think it's really easy for people to just be like, oh, it's just a Unabomber, whatever he says is nonsense. Same thing with Luigi. I don't agree with that, and I think that's a mistake. And it doesn't surprise me that people want to do that, because I think what people are afraid of is recognizing that they could actually have something to offer. I think people don't want to think that. I think it's easier for people to put somebody in the monster category. And you guys know how I feel about that. It's easier for people to just write someone off as a monster for anybody, for any of these cases. Everyone just wants to write them off as a monster or write them off as evil. And I think that for some people, it might be even more scary when you've got people who actually are really, really intelligent and might actually have some good ideas, because people want to put them in the monster category. And so anyway, I don't know. I have a lot of thoughts on this, as you guys can probably tell. But let me know if you're interested in going over any of that stuff too, because we can totally do that. So, okay. So Flash Fan is saying they have 4 brief witnesses. Oh, interesting. 4. Okay. Wow. That is very interesting. Their case focuses more on Bond. Okay, cool. Well, let's get into it, but you guys can let me know if you're interested in any of the coverage of any of those other things I just mentioned.
My understanding is the state doesn't have any further witnesses. Is that correct? Okay. Right. We're going to take let's say a 10-minute recess. Okay. And then we'll start with the defense case.
All right.
Recess for 10 minutes.
50th year.
And you're
Ready.
What's there?
Afternoon.
Afternoon, Your Honor.
That's right.
Thank you, Your Honor. Mr. Coxe, you're an attorney here in Jacksonville, Florida, correct?
Correct.
How long have you been a member of the Florida Bar?
This is the 50th year.
And your law firm, sir, was retained in April of 2022 by Shanna Gardner, is that correct?
Correct.
And that initially followed the publishing of photos of her children by the media.
You did?
Now, I want to fast
We didn't get a first name, but so Mr. Coxe, I'm going to put.
forward to the fall of 2022. Were you aware that Miss Gardner moved to Washington State?
Yes.
Was that done in secrecy, sir?
No, not at all. As a matter of fact, she notified the Duval County school system where her children would be enrolled in Washington.
And in fact, law enforcement executed a search warrant on her home in February of 2023 in West Richland, Washington, correct?
That's correct.
And did the state attorney's office know that you were representing Miss Gardner by the end of 2022?
Yes, they did.
Had you had multiple conversations with them at many levels?
I don't know that I had multiple conversations with them. They knew it.
Did they ever reach out to you and ask you where Miss Gardner was?
No.
Would you have told them?
I would have.
And did you know where she was?
I knew exactly where she was.
Now, after that warrant was executed on Miss Gardner's home on February 6th of 2023.
Like, who's doing the questioning here? Because it doesn't sound like Mr. Carodi. It's definitely not Mr. Sullivan, because he has a very distinctive voice. Definitely not Mr. Baez. But this is the first of the defense witnesses, and this is Shanna's former attorney, who we know she hired counsel, after, I guess, I keep trying to remember if it was after Henry was arrested or after he was charged or whatever the case was. But, and it's not a bad idea, right? Again, anyone can retain counsel at any time, right? Doesn't mean you're guilty of anything. But this was who she initially had hired. So yeah.
At that time, did you start to believe that Miss Gardner may be a suspect in the murder of Jared Bryan?
I think a reading of the search warrants would have made it obvious.
Now, later in February 17th of 2023, there was a hearing about the cell phones that were seized in February from Miss Gardner's home, correct?
Those were in front of Judge Kite.
And so you had more communication with the state
I'm talking really fast. I'm going to put this on normal speed. It's rare that you have to do that these days.
about this case in February of 2023.
Yes, I represented Ms. Gardner in front of Judge Kite.
Oh, it is.
Now,
Thank you.
You became aware.
For some reason, he sounds different now. You know what? It looks like, based on where the gaze of that witness, based on that, it looks like he's at the other podium, which would make sense. Like when we saw Mr. Baez, they went to that other podium, but we're used to hearing from the defense on the podium on the right-hand side. So I'm wondering if maybe the mic is different, and that could be why I didn't recognize Mr. Curdy's voice, because he's over at that left podium, which is where usually we hear from the prosecution.
That Mr. Fernandez was arrested on March 16th of 2023 in Orlando, correct?
Correct.
I approach the witness.
Yes.
I'm now handing the witness what's defendants for. Mr. Coxe, can you please explain defendants 4 in the context of it to Judge Kite?
I had learned from Mr. Jesse Dreiser that his client had been arrested close to Orlando. He let me know that. And so I am almost immediately sent an email to Ms. Stifler in the state attorney's office, letting her know that telling her that if she was interested in Ms. Gardner surrendering, she would do so immediately.
Did you ever receive a response?
So yeah, this does make sense. Again, this is really more, this really points more to bond, right? Because again, this is getting into the fact that she would have surrendered immediately, the circumstances under which they brought her into custody, all that type of thing, and again, because part of this, one of the things they're going to assess is the flight risk, right? Especially when you have access to money. And the idea that she would have surrendered and turned herself in, that would go to say, yeah, they're not a flight risk. Look, they wanted to turn themselves in. So.
Response to that email?
I did not.
Oh,
Now,
right. I remember now. That's this guy. Okay. I didn't necessarily remember. That's Mr. Coxe. Right. And I was calling him Mr. Coxe, but it's Mr. Coxe. Okay. Let me adjust. Thank you. Thank you for that. Let me adjust this. Now I remember. I didn't realize they were one and the same. Okay. Let me fix this on the banner. Actually, I can continue to play this, can't I?
Mr. Fernandez was arrested, did Miss Gardner return to Florida?
No, she did not.
To Tallahassee?
Oh, I'm sorry. Yes, she did go to Tallahassee.
Okay, so she was in the state of Florida.
She was.
And why did she come back to the state of Florida?
I was dealing with a lawyer in Salt Lake City named Tim Anderson, who represented Ms. Gardner's family there for many, many years. I told Mr. Anderson that I had already committed to the state of Florida, that I would surrender Ms. Gardner immediately upon their request, and that was meaningless if she were in the state of Washington. And I recommended she come to Florida and be somewhere in Florida so I could produce on the commitment I made. I talked to an attorney in Tallahassee named Richard Doran, that's Doran, and I said, look, if I have a client come to Tallahassee and live there temporarily, would you be available in case some problems arose? Meaning if police came to arrest her or whatever, and he agreed to do that.
So they should, anytime Tallahassee is mentioned, somebody should have gotten Tim Jensen involved, because he is one of the goat attorneys. Freaking love him. He's on STS all the time. But he's a really, really, really phenomenal, brilliant defense attorney in Tallahassee. He wins all kinds of awards and stuff. He's also just a really, really, really nice human, really intelligent. There was one time when actually Joel, the host of STS, it was when they were streaming. I think it was the first time they were streaming a trial, Gavel to Gavel, and of course it was Charlie Adelson's trial. And they were like the first people on that case from the very beginning, from day one, because they lived near there. And so anyway, but what was funny is so Tim, who's still a practicing attorney, he was able to kind of come on and join on the stream, to give commentary and analysis for, temporarily, right? For if he had a little window of time. And what happened was, yep, I am. Do you know him? He's amazing. And what happened was, something happened to Joel. Joel got booted off or whatever. And it's so funny because Tim doesn't have a YouTube channel. He's not a streamer. He was a guest, he knows how to click on the link and then there he is, right? But what happened was Joel got booted off. And so without any warning, next thing you know, it's full screen, on Tim's face. And now he's running the stream. And he I know from experience, he has no, he's never had to do anything with the stream, right? He's just been a guest. I couldn't freaking believe it. It was, I'll never forget it. And I said so as much because I know how hard that is. The way he just took over, he figured out how to pull up comments. He figured out when to talk during the trial. He was answering questions. He was running the entire thing as if he'd been doing it his whole life. It was so freaking impressive. I don't even know. It was really impressive. But I loved him even before that. He's great. He's really great. So yeah, but it's just funny because when they said Tallahassee, I was like, wait, they should have got Tim Jensen, So yeah.
I talked to an attorney in West Palm Beach named Scott Richardson. I knew Mr. Richardson had previously had experience with.
They did cover today's hearing. I didn't watch it because again, I'm going in chronological order. I didn't want to get any spoilers or be lost, depending on what's happened before that. But they did. STS is covering all the Shanna Gardner and all the Adelsons, of course. And the thing is too, Joel has been actually going to these trials that are in Florida. Like he went to Sarah Boone, he went to Charlie Edelson, and actually Tim's been going with them. I don't even know how that happened, but I remember like, where was it? They actually even went for a day during Karen Reed, I believe. Yeah, I'm trying to remember. They actually went for like a day during Karen Reed, the two of them. I couldn't even believe it. And Tim, dude, he went around interviewing everybody. He had like a little microphone and he went around and interviewed people about their thoughts. Oh my God. And he did such a good job because you know how those people were, right? Like the hatred and the vitriol and the blah. No, I have not seen anyone handle it as well as him, where he could ask people questions and was handling it just, I don't even know what to say. It was so impressive. And he was just like, he was like the beat, you know, like he was out there, like walking around talking to the people. Anyway, but yeah, but Joel, I'm sure will probably want to attend this trial in person because again, he's been doing Florida trials and in the courtroom. And then the COE runs the live stream and then Joel tweets or texts, you know, what's going on in court. It's great. It's great. It works really well. So.
Airbnbs in Tallahassee when he was chair of the Board of Bar Examiners. I asked him if he had a recommendation. He did. I made arrangements with Tim Anderson that Ms. Gardner would come to Tallahassee and stay there, and we would wait to hear from the state of Florida.
Did you ever hear from the state of Florida?
Never.
And at some point, she also went to Savannah, Georgia, which was also in striking distance of Jacksonville.
She went to Savannah, Georgia because her parents determined to visit her when they could. Travel between Salt Lake City and Tallahassee was very, very difficult. Savannah was much easier than Tallahassee. So I called a lawyer named, I'm trying to remember her name, Amy Copeland, who was recommended to me by John Ossick in Georgia. She's in Savannah. I said the same thing to her that I said to Richard Doran. If problems come up and if I make arrangements for a client to stay in Savannah, would you be available to help if I need help? She recommended an Airbnb in Savannah, and that's where Miss Gardner went to from Tallahassee. The advantage of Savannah was twofold. Number one, it was easier for her parents to get to. And number two, it was about the same distance from Jacksonville to Savannah as far as me being able to produce Miss Gardner whenever they said we want to arrest her.
Okay.
So that's where it was. I will also add there was another reason for going to Tallahassee and Savannah, and that was Mr. Anderson, the family,
What this sounds like is like she actually tried to turn herself in and they had plans. I'm sure we'll hear about it. And so she was in the area, she was in Savannah, you know, but it's just, you know, get over there to Jacksonville. And it seems like, you know, okay, now I'm putting two and two together. Remember how with the previous witness, I think this was on direct, it came up that she was going around. And remember, I was like, oh, wow, like she didn't just go straight to Washington. She was here and there. And they mentioned Tallahassee, and I think they mentioned Savannah. And I was like, what? Weird. So this is before she goes to Washington, I guess, right? Or maybe she went there and came back. But basically, now they didn't explain what that was about. And now we know what that was about was her trying to get out of Jacksonville because, you know, according to the defense, right? Get out of Jacksonville because of all the publicity and the people being annoying. And I can understand that, right? But stay close enough to where she could turn herself in. And I think what they're going to suggest is that the state didn't follow through. Which if they didn't, shame on them, right? And then she has every right to go on with her life and go to Washington, right? Because again, it's like, well, if you don't turn yourself in, then you know, and there's a reason for this, right? There's a reason for this. And I don't think this should be, you know, this sucks, right? The thing is like when these attorneys for anybody make this type of deal, right? Where there's going to have somebody turn themselves in, that benefits the, you know, the suspect or the, you know, depending on what's going on, right? The person who they're interested in, the, you know, that benefits them because then, and we heard the same thing with P. Diddy, right? It benefits them because then they're more likely to get bail or get bond, right? Because they're like, look, I turned myself in, you know, obviously I'm not a flight risk, right? So you might say, well, then why the heck does, you know, whether it's the federal government or the state, why do they make these deals and make these agreements with people and then wait and then not let them turn themselves in and then pounce whenever the person isn't already there? And the reason is it's because of that, right? Because if they arrest them and bring them in, then they can still argue that they would be a flight risk. So it sucks though, because people make these arrangements, right? Like that was one of the P. Diddy's big things was they were like, you know, he went to New York City and he was there. I don't remember how early, but he was there way early to turn himself in or whatever. And, you know, and so it sounds like a similar thing here. I think they said it was 4 months of time where she was in the area, but not moved to Washington yet. So she essentially, it sounds like 4 months she was like, okay, I'm here. And they didn't take her up on it. So then she moved to Washington. And then once she moves to Washington, then they come and arrest her and then they extradite her. And so you can see where all this is going.
Everyone in my firm
Oh, interesting.
knew that if it was an arrest in Seattle, I mean, not Seattle, Western Washington, it's not Eastern, it's Western Washington, that it would be done by several officers in the presence of her children. And we were doing everything we could to try to avoid that.
Right.
That's why we went to Tallahassee. And then
well, that's a good point. That is a good point. In this case, they should have honored it because of the children. To be honest, like that's fair. That is fair. Whether or not they would be beyond anything else, right? They should try to do it not in front of the children. And I commented on that. When we watched that body cam, I said I couldn't believe it because they had so many people with those huge guns that looked terrifying, and the kids were, and I couldn't believe it. I said so. I was like, yeah, even as an adult, to me, that would be scary with the guns. And so the fact that they did that, and that even came up yesterday in the first half where they were asking about it, was that really necessary? And, having the one thing I can say, that when the detective was like, this is pretty much par for the course, and like, we never know what we're going to find. That's true, right? However, the thing is that had they taken her up on this offer to turn herself in, they could have avoided it, right? It didn't have to happen, but they made sure that it happened. But yeah, but this is a really good point, right? Because this way they can ensure that the kids aren't going to be there and all that.
And Miss Gardner stayed for at least several months in the general area of striking distance to Jacksonville, awaiting essentially for the state to reach out to you, correct?
She did.
But that never happened, and she eventually returned to Washington State.
No, and that was because after so much time, it was just, well, they know where she is because they was there when they served the search warrants. So they know where she lives in Washington.
I mean, think of it this way, guys. Think of it this way, right? One of the things that, and rightfully so, everybody, well, Henry already pled guilty, but as for the other two, Shanna and Mario, they're innocent until proven guilty, obviously. But one of the things that they are charged with is that, what is it, like the aggravated abuse of a child because of the child being in the car. Okay. Here's what I will say. We read that statute. We read the elements of that charge. Okay. And one of the things on there, it beyond physically harmed. It doesn't have to be physically harmed. It says like you create, I'm paraphrasing, right? But emotional harm, right? Or emotional stress, fear, that type of thing, right? Okay. This is the thing I can't stand. You guys know I have no tolerance for hypocrisy. Absolutely none. So here's the thing. Whether or not they knew the child was going to be in the car or didn't know the child was going to be in the car, that actually is immaterial to what I'm about to say, which is this. That charge, they are adding that is a criminal charge, okay, for potentially causing emotional harm to a child. And we don't know yet. They might not have known she was in the car, whatever, but regardless, you know what? The law enforcement officers had the opportunity to arrest her when they knew the children were not there. But they chose to arrest her at home in Washington when they knew the children were there. So do you guys see where I'm going with this? Because technically, and by the way, that statute for the child thing, it's under the age of 18. It's not under the age of like 2, it's under the age of 18. So that would still, in other words, when you look at it, it really could apply. Like if we're being fair here, right? Couldn't these law enforcement officers, of course, it's never going to happen, but this is my point. Technically, the amount of fear that they caused with those, I don't even know what type of gun, huge ass machine gun type things, right? Coming in there with a bunch of them, and those children are actually old enough where they will remember it. And they were there. So they're allowed to cause emotional stress and potential harm to a child, right? So you guys see how this is just, and the thing is that they could have not done that. They had a way around it and they chose not to. So in a way, it actually makes what they did worse, honestly.
And now so much time had passed. She wanted to be with her children. It was understandable. They were having with their anxieties from being away from their mother. So we said, well, let's just gamble and let her go back and see what happens.
Thank you, Mr. Coxe.
Thank you.
Mr. Coxe, why not Jackson?
Primarily because of the media attention, and anywhere she went, someone would say that's Shanna Gardner.
That was the only reason why she didn't pick Jackson.
You already explained this.
No, there's no fear of being arrested. We're willing to surrender. Why else? Why would we be here to be on TV all the time? As a matter of fact, local television went to Western Washington to her home.
You would agree that it is common for defense lawyers to let the state of Florida know that they can turn in their clients.
Depending on the circumstances, certainly, yeah. It's not uncommon.
Obviously, if you've already been retained.
I was representing her, yes.
So you would agree that typically, the more violent the charge, the less likely the state takes you up on an offer.
Not necessarily. I think it's a matter of evaluating all the circumstances.
Well, you would agree if it were a warrant for, a DUI or domestic violence.
Here's the thing. What he's saying is true or not, I don't know. But here's the thing. It doesn't make any sense because what he's trying to say is that if it's like a more like a misdemeanor charge, right? Like a DUI or whatever, that they let them turn themselves in. But that if it's more of a violent or serious, crime or whatever, then they want to surprise them. How does that make any sense? How does that make any sense? Because you know what? You're more likely to endanger yourself if you're a law enforcement officer, if you surprise somebody, right? If you surprise somebody, I mean, how many times do we see accidental shootings happen like this all the time, right? If you surprise somebody, oh my God, this is just dumb. Whereas if they're turning themselves in, they will already have been cleared for not having weapons, right? Anyway, it just doesn't make any logical sense. Yeah, me too. YouTube is, yeah, there we go.
So if you like that, the state of Florida would be more likely to take you up on a voluntary surrender as opposed to a murder or an armed robbery.
Well, Mr. Mizrahi, I've had that experience cut both ways on all kinds of charges. So to say it's the most serious charge, therefore I'm not going to get notice ahead of time. I would have been perfectly willing to say she is at such and such an address in Tallahassee, Florida, waiting for you. Such and such address in Savannah, Georgia, waiting for you.
No, again, I'm not saying that there aren't situations where first-degree murderers turn themselves in voluntarily, or DUIs, they go and arrest you. But you would say, generally speaking, with your 50 years of experience, the more violent the case, the less likely that the state of Florida would take you up on that offer.
With some prosecutors, yes.
That's all the question I had.
One reader.
Sure.
Mr. Coxe, Mr. Mizrahi kept using the term first-degree murderer. Is it your understanding that Ms. Gardner is charged as a principal in this case?
I have not been involved in the details. I've read the indictment. The indictment says first-degree murder.
It's the same for both of them.
Mr. Crady, I think Mr. Cox has the exhibit still.
Yep, I'll retrieve that.
Thank you.
Thank you, Mr. Coxe.
Maybe, please.
Yes, Your Honor.
Thank you.
Okay, next witness.
Call your next witness.
We'll call John Curry. He's by Zoom, Your Honor.
Okay.
I can hear you. How can you hear me?
Yes, thank you. All right, if you'll raise your right hand, be sworn in, please.
Do you solemnly swear or affirm testimony you shall give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, you may proceed.
Mr. Curry, thank you for your patience. Sir, you're a retired naval aviator, is that correct?
That's correct.
And you're now an airline pilot, is that correct?
That's correct. Yes.
And also, until recently, you were a lay clergy member in the Church of Jesus Christ of the Latter-day Saints, is that right?
That's correct.
And we'll just refer to it to the church as we go through the questioning, okay?
Sure.
What is a ward in the church?
A ward is the name that we call a local congregation that's a division of the church that's set by a geographic boundary. So that's just the name of a congregation.
And is there a bishop over the ward?
Yes.
And what are bishop's responsibilities over a ward?
A bishop's responsibilities generally are pretty broad, but they're administrative in nature, in charge of the record keeping, finances, ensuring the ward is properly staffed to serve the congregation, as well as providing counseling and spiritual guidance to its members.
And were you bishop of a ward until recently?
I was.
Which ward?
The Jacksonville Beach ward.
And from what years to what years were you the bishop of the Jacksonville Beach ward?
I began bishop in the spring, April of 2018. I was most recently released in March of this year.
Sir, do you know Shanna Gardner?
I do.
And approximately when did you meet her?
It was in the spring of 2018 when I became bishop is the first time I met her.
And was she a member of your ward in 2018 when you took over?
She was a member of the ward. I believe she had just relocated into the boundaries of the ward. So she was a member shortly after I took over in 2018.
And were her records kept in your ward?
They were.
And did she ever officially resign from the church during your time as bishop of that ward?
No, she did not.
Did she periodically attend services during that period of time that you were bishop?
Yes, she did.
Did she attend with her daughter at times?
That's correct, at times.
Did Ms. Gardner remain friendly with many members of the ward up until she moved from Jacksonville Beach?
Yes, as far as I'm aware.
And did that include members of your family?
Yes, that's true.
And did it include other women who were fully involved in the church?
Yes, as far as I'm aware, that is true.
And when Ms. Gardner's family from out of state would visit, would they attend your ward?
Yes.
And so in 2022, Ms. Gardner still had many connections to the church. Is that fair?
That's fair, yes.
I want to talk about baptism, sir. With regard to Ms. Gardner's children, were they registered in your ward?
They were not.
And do you know whose ward they were registered in?
Yes, they were in their father's ward, Jared Brightigan's ward.
So I
And
wonder if
what-
what they're going to be talking about is the fact that that Shanna didn't oppose them getting baptized. She wasn't against Mormonism, but that she wanted them to be baptized in her ward, because that would make sense, because the ward thing is really funny with this. It's like a big deal. It's like clicks. I don't really know how this goes to bond, although it would go to refute some of what the state presented in terms of them saying that that was another point of contention. So we'll see.
What does that mean that they were registered in Mr. Brightigan's ward?
It meant that their progression in the church would be under the purview of that ward and not their mothers. So the record, I would have very little purview over anything related to their membership.
And with respect to baptism in the church, do both parents need to consent to baptism?
Under some circumstances, I believe they do not. It's an administrative matter that I'm not, up to right now, I'm not familiar with it enough, but generally it's not necessary from my recollection.
Now, at some point, did you become aware that Ms. Gardner's daughter desired to get baptized?
Yes,
And is it also part of church policy that a child should understand the blessing of baptism before they are baptized?
yes, I would say that there is a minimal level of understanding that would be expected, yes.
And what, if anything, did Ms. Gardner ask you to do with respect to the child baptism?
She asked if it would be okay if we went ahead with some discussions to help her prepare to better understand and answer those questions.
And when you say questions, are those questions that relate to the blessing?
Just general questions about understanding what you're doing and the commitment. It's a covenant, so it's just an understanding of the covenant that you're going to be making.
And as a result of that conversation, did you arrange to have the daughter meet with the missionaries?
Yes,
And did that occur?
it did.
And did that occur during the weeks that the child was living at Ms. Gardner's home in Jacksonville Beach?
Yes,
And are you aware of whether or not Ms. Gardner brought the child to these meetings?
I am aware that she did.
And did she make any attempt in any way to obstruct her child from receiving the education from the missionaries, to your knowledge?
She did not.
Did she ever show opposition to the child being educated by the missionaries in the church?
I saw no indication of that at all.
And sir, did you ever reach out to Mr. Brightigan's bishop to make that bishop aware of what you were doing with respect to providing education to the daughter?
I did.
And would you say that this was a coordinated effort
I would say that, yes.
that would culminate in the child being baptized in the church?
Yes.
Thank you, sir.
Cross.
No questions.
All right, may this witness be excused?
Yes, Your Honor.
All right, thank you. Thank you both very much.
Yeah, thank you, Judge.
Mr. Pretty.
Judge, we would call Marlow Rogers.
Marlo Rogers, please.
I didn't catch the first name. Hold on.
Mr. Pretty.
Judge, we would call Marlow Rogers.
Marlow.
Marlow Rogers, please.
I don't know that it's spelled correctly on the thing.
You promise for her testimony to give the truth, the whole truth, and nothing but the truth.
Marlow. Probably OWP.
Mr. Robinson, can you hear me? All right, Mr. Pretty.
Ms. Rogers, can you tell Judge Kite what city and state you live in?
I live in West Richland, Washington.
And up until she was arrested in August of
Yeah, I wonder
2023,
if she's the one with the big like tour bus looking thing. Remember we saw that in the body cam? I was like, what is that? I might have called it a van, but it was like a tour bus.
in West Richland, Washington, how far away from you did Shanna Gardner live?
Other side of the country.
No, prior, at the time of her arrest in August of 2020.
Oh, sorry, next door.
Mr. Pretty, the microphone.
Sorry.
It's okay.
Next door to you?
Yes, sir.
Do you have a tour bus? And why?
Ma'am, what do you do for a living?
I am a self-employed baker.
Is that the same type of business that Miss Gardner ran in Jacksonville Beach, Florida, until she moved to Washington?
Yes,
When did you meet, when I says, do you know Shanna Gardner? Do you know her?
yes.
All right, when did you first meet her?
I met her in February of 2020.
Can you tell Judge Kite how you met her?
We both attended solo at a cookie convention.
Is that called CookieCon?
It is.
All right, and is what is CookieCon generally?
It is a place for cookie artists to go and learn and be creative within the cookie world.
And did that help facilitate your business as well as Miss Gardner's business?
It did.
And you said that was 2020. Was that before the COVID shutdown?
It was
How far before?
about 2 weeks prior.
Now, during this CookieCon 2020, how quickly did you and Miss Gardner become friends?
Very quickly.
And then after that, I imagine you returned to Washington and she returned to Florida.
Correct.
And did you continue to talk to her during COVID?
We did.
Now, were you and Miss Gardner planning to attend CookieCon in March of 2022?
We were.
And did Shanna end up attending CookieCon in March of 2022?
She did not.
And why not, if you know?
This was after the death of the twins' father, and she wanted to stay behind to be with them.
But prior to that, had you and her had several conversations about her coming to CookieCon?
Correct.
In your world, is CookieCon a big deal?
It's a huge deal.
Had Miss Gardner registered and paid for the hotel?
I believe so, yes.
Ma'am, I want to talk to you about August of 2022. Did you visit Jacksonville Beach, Florida in August of 2022?
With my family and myself, yes, we went.
Was the purpose of that visit to see Miss Gardner and her family?
It was a family vacation for us to see her, yes.
Where did you stay?
We stayed at the Gardner's Beach House.
Is that the house on
Crazy.
Ocean?
They were really close
Yes.
then.
And during your visit here in Jacksonville, did you and Miss Gardner have discussions about how her business was doing financially?
We did.
And did she tell you that essentially she lost all her business because of social media?
Correct.
Out of that conversation, was there a second conversation about her moving to Washington State?
We joked about it because there was a house being built next door to me. And from the time that I met her, we talked about starting a business together. And so I brought up that there was a house next door and left for her to be my neighbor.
Okay, so sort of joking with her, but telling her she should come out and be your neighbor.
Yeah.
And work with you.
Correct.
Now, you're aware that her son, you know her children, correct?
I do.
And they live next door to you for over a year at this point.
Correct.
And one of her son actually has a heart condition and can only live at certain sea levels, correct?
Under 1,000,
And what is the elevation of West Richland, Washington?
approximately 600.
So the child, that's one of the places the child can move.
It would be a safe place.
And after you had left and returned to Washington, did Miss Gardner end up coming out to Washington, to West Richland?
She did.
How soon after?
After our vacation,
Correct.
approximately a couple weeks.
And did you see her during that visit?
I did.
What did she do?
She looked at the house. We looked at schools, and we just a variety of the things that you would do when you move into a new area.
And as a result of that visit, did she decide to move to West Richland and become your neighbor?
She did.
Now, between when you met Miss Gardner in 2020 and when she flew out to Washington State, have you ever had any conversations with her? Or did she ever seem willing to leave Florida?
No.
Now, after Miss Gardner moved to West Richland, did she help you in your cookie business?
She did.
And did you interact with her regularly?
I did.
How often?
Daily.
Did you go over to her house?
I would.
Did she go over to your house?
She would.
And you were aware that there was a search warrant on her home, the home next door to yours, in February of 2023.
Correct.
And then I imagine you became aware that her estranged husband, Mario Fernandez, was arrested in March of 2023, correct?
Correct.
And was there a period of time that Ms. Gardner had left West Richland and returned back to the southeast?
Yes.
Now, in all of your dealings with Ms. Gardner since she moved to Washington up until her arrest in Washington in August of 2023, did you ever see anything that indicated to you that Ms. Gardner was going to flee?
Absolutely not.
How about evade arrest?
No.
Did you ever know her to engage in any type of criminal behavior as your neighbor?
Absolutely not.
Was she threatening in any way to you?
No.
Did you ever see her be threatening to any of your neighbors?
No.
Had she established herself in the Washington community?
She had.
And can you tell the judge how some of the things she did to establish herself?
She always put her kids first, and one of those being in her children's activities, particularly AB, who loves gymnastics, and so she was very involved in that community.
And as far as your street where you all live, did she have a reputation among the neighbors?
A good reputation.
Ma'am, have you had an opportunity to see Ms. Gardner parent her children?
I have.
And with regard to her son, for lack of a better term, at times can be challenging, correct?
Most preteens can.
And have you been able to observe that Ms. Gardner has been able to connect with her son better than other people?
Absolutely.
Would you say they share a special bond?
They do.
Pointing to the fact that
Thank you,
she's with her kids.
Well,
Yeah,
Good afternoon, Mr.
she's nervous. I don't blame her. She's, it's got to be awful. You've never done something like this before.
So would you agree that Ms. Gardner helped you in your business?
she did.
Was she would you consider a savvy businesswoman?
Yes.
Did she give you ideas about how to make your business more profitable?
Yes, I would say that. Sure.
And you didn't know her at all before 2020.
No, sir.
So typically when people have that bond, like you said, that quick bond, they tend to learn about their history.
Yes.
And so did Ms. Gardner share with you her history with regard to Mr. Bright?
Yes, sir.
What did she say about their divorce and their custody issues and things like that?
I'm sorry.
What did she tell you about the divorce and the custody issues and things like that?
I can't remember specifically, but I am a child of divorce, so I quickly could relate to what she was going through.
Okay, so you don't remember any specifics?
Other normal, I would say,
Was she ever frustrated with Mr. Bright again, the things he was doing?
possibly, but nothing in specific as far as conversations or things. But
She would,
I guess my point being, yes, I could say that she was frustrated.
well, sure, but nothing like what you saw in the text messages in terms of threatening to kill him or anything like that.
No.
What did you know about Mario Fernandez Saldana?
That he was her husband. I don't know much about him.
Did you ever meet him?
I met him once when we came in August of 2022.
Same question about his relationship with Bright again. Did you know anything about that?
No.
When you heard about the death of Jared Brightigan, did you hear that from the defendant?
Yes.
And when did she tell you that?
Maybe the day after it happened, or a couple days later. I couldn't be certain.
And no one's going to hold you to the specific time. It was relatively close.
Yes.
It wasn't like weeks or months later.
No, sir.
And what did she tell you?
I'm sorry.
What did she tell you?
That she would not be attending CookieCon, that she would be staying home because of the event had happened.
Did she tell you any details about the event?
No, she did not.
Did you ask?
No, I did not.
Did you ever, in subsequent discussions with Ms. Gardner, ask about what she thought had happened?
Maybe months later, but not right after it happened.
So tell me about the months later.
She just mentioned that she wouldn't have known what had happened, that they didn't talk to the same people, maybe just theories, but nothing that I could recall specifically.
Did she ever utter a word about suspecting that Mario was involved?
No, sir.
Did she ever utter a word to you suspecting that Kirsten Brightigan, the current wife, was involved?
No, sir.
Did she ever utter anything about drug dealers or gangs or anything like that?
No, sir.
She basically said, I have no idea.
No, sir.
That's what I mean.
Yes.
Yes. Did she ever mention Henry Tenon?
No.
Did you have any discussions with her after Mr. Tenon's arrest for driving on a suspended license?
No.
Did you ask her why she had a PR firm?
We did talk about that because of the harassment that she had received from social media.
And how is the PR firm going to help her with harassment from the social media?
I didn't ask specific questions to that.
What is your relationship with Ms. Gardner now?
In my eyes, she's still my neighbor and still a friend.
Well, during her incarceration, she's not your neighbor. So what is your relationship during her incarceration? Since she's been incarcerated?
A friend?
Do you talk to her daily?
No, not daily.
Do you communicate with her over the tablet, phone calls, and things like that?
When I'm able to, or she's able to.
That's all the question I have.
Redirect.
No, Your Honor.
May this witness be excused?
Yes, Your Honor, thank you.
Thank you. Call your next witness.
Your Honor, we call Megan White.
Megan White, please.
Someone swear or affirm testimony you give shall be true, the whole truth, and nothing but the truth, so help you God?
Witness number 4. 1, 2, yeah, witness number 4.
Seat right here.
Mr. Curdy.
Thank you, Your Honor. Ms. White, where do you live?
I live in Alpine, Utah.
And what is your relationship with Shanna Gardner?
I'm her older sister.
And can you please
What was
explain to Judge Kite where you
What
fit?
was her first name? Hold on. You never catch the first name. Megan. Okay. We got it.
Someone swear or affirm testimony you give shall be true, the whole truth, and nothing but the truth, so help you God?
Just go. Seat right here.
Mr. Curdy.
Thank you, Your Honor. Ms. White, where do you live?
I live in Alpine, Utah.
And what is your relationship with Shanna Gardner?
I'm her older sister.
And can you please explain to Judge Kite where you fit in the Gardner family?
Shelly and my dad got married when I was 5. So I'm from a previous marriage.
And how many kids do Shelley and Sterling
Oh.
have together?
They have 4, 5 counting me.
And are they all daughters?
Yes,
And where does Shanna fit into the 5 of you?
she's the baby.
Have you maintained a close relationship with your sister Shanna since she became an adult?
Yes,
So the
And
thing
you have a
is,
niece and nephew through Shanna the twin.
I do.
And they're now 12 years old, is that right?
Correct.
And there are a few subjects I want to talk to you about.
there's a couple things. So just, I mean, I know that the bond is going to be denied, you know, it usually is, but just in thinking about it, right? One of the things I like to look for is like, you've got a lot of family members who are going to be there to basically babysit you essentially, right? Support, because you're going to be on house arrest, you know, that you've got people that are going to be there that look trustworthy, blah, 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 right? One thing that I'm thinking about though, is the fact that, you know, one of the grounds on which they want to get her out is so she can be with her kids, right? But what I'm thinking is like, if they're saying like the sister, I don't know, I'm sure they'll get into it more, but just with the sister, if this like older sister is going to be the person who's going to be like the babysitter, so to speak, right? You know, because of the fact that Shanna's son can only live at certain altitudes or whatever, you know, she said she lives in Alpine, Utah. Now, Utah, I would have thought is kind of low to sea level or whatever, but Alpine, I don't know. Is that like a mountain area? Because what I'm wondering is like, you know, what would happen if like Shanna's son can't live there, right? And maybe they'll talk about it. Maybe Shanna's sister would go and live out there in Washington. I don't know. You know, I don't even know what happened to the house, but yeah.
For the purposes of this motion is set of bond for your sister. And the first is Shanna's move to Washington State in the fall of 2022. So let's go back in earlier 2022. Had you visited your sister
Having
Shanna?
said that, we know that okay, hold on. Having said that, we know that the parents also live in Utah. Now, I don't know if they live in Alpine, but we know that they have custody of the children. So unless they moved, but basically the children are with the parents, and it's got to be somewhere apparently where, you know, is not detrimental to the son. So
You're in Jacksonville that year.
We came to Orlando that year, and she came with the kids to see us.
And were you aware as to whether or not in 2022 your parents, Shanna or Sterling Shelley, whether or not they had bought a house in Jacksonville Beach?
Yes,
And was that a discussion amongst the family that they were buying that house?
yes,
And what did the family call that house?
the beach house.
What was the purpose of the family buying the beach house?
So that when we came to Jacksonville to visit, we'd be able to stay there.
And was that located at 2709 Ocean Drive in Jacksonville Beach?
Yes,
That house was purchased shortly after Jared Bryan was killed in February of 2022, correct?
correct.
But the family still bought
Yes,
And did the family also buy a minivan
Yes, they did.
to keep at the beach house?
Yes,
Can you tell the judge why they bought a minivan?
to cart many people back and forth from the airport to the beach house, to Shanna's house, wherever we needed to go.
And was it the intent of the family to have the beach house to essentially facilitate visiting Shanna here in Jacksonville?
Yes,
Prior to early fall of 2022, did you ever expect your sister Shanna to move from Jacksonville Beach?
No.
And why did you not expect her to move?
because she stated she had roots here. She wasn't interested in leaving. She had a business. There was no reason for her to go.
And did that hold true even shortly after Jared Bridegan had been killed?
Yes,
And because you actually came to Jacksonville shortly after Jared Bridegan had been killed, is that correct?
yes,
Can you tell Judge Kite the circumstances under which you came to Jacksonville?
yes. I and a lot of my family came for the memorial for Jared.
And when you mean memorial, what are you speaking about?
The event that Shanna planned, so that the children could have time to mourn their father and have closure.
I wonder if there was
And-
more than one event because Shanna planned it. You would think it would have been Kristen. That's interesting. Oh, YouTube rejected your comment. I'm sorry. I don't know. Weird. I know
The
they've been.
extended Gardner family or many of them flew in for that?
Yes,
And was it organized?
it was very organized.
Who organized it?
Shanna
Where did it take place?
at the beach house.
Was there a photographer there?
Yes,
Why was there a photographer there?
because Shanna felt because the kids were so young, she wanted them to remember that day. She wanted them to have a reference of that day
About their father?
about their father.
I
Now,
wouldn't have asked
I
that.
want to fast forward to,
I wouldn't have asked that question because this did not come up. So the reason he's asking that question, my guess, right, is that why would you mention it at all, right? You would mention it if, let's say, if the state had brought up this memorial and said she brought a photographer there. You know, this is something that might come up in the trial, right? But like it hasn't come up yet at this point until now. But like if the state was like, yeah, she hired a photographer because she wanted to make appearances look like she cared when she didn't care because she killed him, right? So the fact that he brought it up, it's like that was a little bit of a misstep in my opinion because we haven't heard that. I say we as in the public, but maybe Judge Kite probably hasn't heard that either, right? Because they're just getting into the beginnings of this. They've been dealing with all this privileged information and the potential breach and all that. So it's sort of like, you know, and this whole thing is before, it's like the point of this is for Judge Kite, right? But it's also for the public, but it's for Judge Kite and the public. So if none of us knew this, right? So in other words, the only reason to ask that question is because you would know, maybe you thought the state did, or you would know that the state could or would or will try to make it seem like that was something that was, fishy. But normally what you would do is if the state hasn't mentioned it, don't mention it, right? Because now, like, in other words, now you've just drawn attention to the fact that that matters. And like, does that make any sense? It's almost like defending something, but before there was any accusation made. So now you've just drawn attention to it to make it seem like there should be an accusation there, if that makes any sense. So I would have not asked that because, like now I'm assuming that the state is going to say or has some reason to believe that that photographer was for some other purpose, right? I wouldn't have thought that except for he asked that question. I mean, because otherwise you would think, if like, in other words, it would be normal to have somebody to take pictures, right? Like that's normal, but drawing attention to it now, it seems weird.
fall of 2022, had things changed for Shanna in Jacksonville Beach?
Yes,
What had changed?
her business was failing. Other kids at school were saying things to her kids that were not nice. She was being bullied by the media. The children were not feeling safe, and neither was she.
That makes
And-
sense.
Ma'am, we heard from Marlow Rogers, but her son, your nephew, has a heart condition.
Yes,
How does that limit where he can live?
Okay.
he can't go anywhere above 1,000 feet elevation.
But one of the places he could go was West Richland, Washington, where Marlow Rogers lived.
Yes,
And Ms. Gardner ended up moving to West Richland, Washington. Is that right?
that's correct.
Did you facilitate that move?
I drove with her cross country
In what vehicle?
in the minivan that was purchased here in Jacksonville.
And did Ms. Gardner do anything, or did you make any observations of Ms. Gardner as you all left the state of Florida?
Yes, as we were crossing the Florida line, she became very emotional and started crying.
Did she have any outbursts or say anything when she was crying?
I I asked her why she was crying, and she said that she was heartbroken because this was her home, and she felt like she was being run out of her home.
Now, after Shanna was arrested in August of 2023, who had been the primary caregivers for her children?
She had been.
And after her arrest?
After her arrest, they got Shelley.
And how old is your father?
He's 74,
And how old is Mrs. Gardner?
62.
And have they essentially moved to Washington State?
Yes.
There it is.
Uh,
Okay.
Fly out to Washington
That
State.
answers my question because that's what I was thinking, right? That's what I was thinking. I was like, because I don't know that he could live in Utah. So that answers my question. So the parents moved out to Washington State so they could basically be the caregiver for the, guardian for the children.
For Utah to assist them.
I do.
About how often?
It's worked out to be about every other month for a week.
When you go out there and essentially, I imagine you're giving your parents a break, is it?
Yes.
When you go out and give your parents a break,
It's really sad because these two children, right? They lost their dad. And I don't know how close they were to Mario, but they essentially lost him too, but they lost their dad. And now their mom, who knows if they'll ever get to see her again or she'll ever be, who knows, right? But essentially, and that happens in all of these cases. But one of the differences here is that I was just thinking about the difference that it makes that this son has this condition, because essentially now look at the effects on the rest of the family because of the fact that he can only live in certain places. So essentially what you're hearing is like the parents had to up and move. Now, of course, they have all the money and resources, but still, right? So it's one thing if they could the children could come to them, right? But they had to move to Washington. Now she's going out to Washington monthly to visit. You can see, like, in other words, it's really beyond, it's tragic for the children, obviously, but it's also really impacting the rest of the family because of the fact that he can only live in certain places. It just adds to it.
have you observed the impact on the twins by their limited contact with Miss Gardner?
Yes.
Can you tell the judge about the impact?
There have been several times when they've become upset and they've expressed wanting to speak to their mother. And because she can only speak to them certain times of the day, she's not readily available for them.
And does she have a special connection with her son?
She does.
Can you tell Judge Kite about that?
There have been times where LB has had problems when he's been struggling. And later on, when Shanna has called, we'll find that she's been having a rough day also. So it's a connection that goes beyond distance.
Well,
Now,
I find that odd because why does she only have a special connection with one of her kids? I mean, really, I don't know. Does anyone else find that odd? It was a weird question, right? Because, that question almost assumes that the answer is yes. But to me, that's odd because shouldn't a parent have a special connection with each of their kids? I don't know. Does anyone else think that's odd?
were you ever aware that Miss
I know,
Gardner had left
right?
her children in
Yeah.
Washington and come back to the Southeast after Mr.
And the thing is that, if there's a lot of things, why do people go to jail, prison, right? Why? So there's the, we always hear about this in sentencing, right? There's the punishment, right? Punishment for the crime. There's the future danger to society. There's deterrence. And I think that's pretty much it, isn't it? Am I thinking of anything else? Yeah. Punishment, deterrence, future dangerousness. And, ideally it's rehabilitation, right? But anyway, but when you look at somebody, like, let's just say that Shanna did this and she's found guilty, right? I think if you were to assess each and they do, different states do it differently, right? But when you think about like the pre-sentencing, PSI reports, right? If you look at someone like Shanna, who has no criminal history or whatever, right? I mean, at all. I didn't even see a speeding ticket when I was looking her up on the Duval County, website. It's sort of like, even if you go with, okay, maybe again, in the event that she's convicted, you say, okay, she killed Jared. When you think, what are the odds that she would do this again to somebody else? I mean, they're probably slim to none or none, right? I mean, I think that's, when you look at the threat to society, right? When you look at the dangerousness, when you look at all those things, I think really the only thing to keep her there would be just the punishment factor. You know what I mean? So if punishment means custody, right? Even if it's LWOP, okay? There's a way, like, if you're going to do that, right? I'm just thinking about this theoretically. If you're going to do that, right? there should be a way, right, where, and I understand, I guess in the prison system, it's hard because they've got so many people and they can't just like, they put people and it's like the same rules apply to everybody, right? But really, when you think about it, it's like, if you think the punishment's that bad, but you've recognized that they're not really a threat to society, wouldn't that be an example of where you put these people in a different category? Because what I'm thinking is like, you know, if you want her to be in custody, you want her to be punished, you know, it seems reasonable that she could still have maybe visitation rights, you know, and more, you know, because there's limitations on that stuff, right? Like that she should be able to see her kids. You know, I've heard of this in other states. I'm trying to think of where it was, where they had somebody who had LWOP or whatever. They were LWOP, but they had arranged it to where like once a week or something. I'm trying to remember which state what this was. Like once a week, and they were taken by, you know, law enforcement. This is I think is a really radical idea that makes a lot of sense. They were brought to this like separate house. Okay, has anyone heard of this? They were brought to this like separate house, you know, and the family, you know, they had the kids and the parents and, you know, their, you know, whatever, the family would meet them at this like separate house, and they got to have like a weekend or whatever, like a little, you know, and they would you know, they would do all the shopping, and then they could, and literally, and this is without handcuffs. It's like they're living a normal life. Okay. Now what would happen is that they weren't on camera. Okay. Now what they would have is they would have somebody from the prison come and like just check up on them like every couple hours or whatever, right? And it might have been by phone or it might have been in person, but they had a way to do it. Now this is after it had been determined that this, I don't remember who it was, but this person who had LWOP, right? It had been determined that they were not a threat or a danger to anybody else, that it was safe, and the family all agreed that it was safe. Like they went through it, and like this is, I think, is a really great idea, because what it allows for is it allows for some normalcy for their loved ones, where and it's not just for a 1 hour visit at the prison, right? Again, they go, and it's like a house where they stay overnight and they live a normal life. And, you know, and they, you know, the family packs their suitcase, you know, and they come and they stay there. And I think they get like a weekend, and maybe it's not every week, maybe it's like once a month, right? But still, that I think is a really, really, really great approach to something like this, where you've got somebody who, I don't know, it's just something to think about, right? Because again, just thinking about her kids, right? And again, even just the thought that they're trying to kill her, even worse, right? But I was just thinking, even if, regardless of if it's death row, they're never going to give her those privileges. Although I still think, I mean, again, it's like, can you imagine though? It's like, can you imagine that, like, if she's convicted and they do go for the death penalty, I still think a PSI would show that she's not a threat to anyone else, which is what's so interesting, right? Can you imagine? It's like, you're not really dangerous, but you're on death row. Like, that doesn't compute. But anyway, I don't know. We'll get to those death penalty motions. I'm not going to go deep into that yet, but yeah. But just thinking about even killing her or not killing her, just thinking about her kids and her family. And, you know, again, I don't think you need to punish somebody, right? Again, because the element, right? Punishment, right? I don't think you need to punish them by like also punishing the family. Because if the family and the loved ones want to see them, now there's probably some people in custody who the family doesn't care, right? They don't want to see them. You know, obviously that's often the case. But when you've got a family that wants to still see them, it's punishing the family also, right? And that's not fair. So again, the punishment is that they're in custody. The punishment is that they've lost their freedom. That's the punishment. So you can still keep them in custody, like that example I just gave, right? You can still keep them in custody and punish them that way, right? But still, there's ways you can do it where they're allowed to still see their family and have some sort of normalcy there, where it's not punishing the family as much, if that makes sense. So.
Hernandez had been arrested.
Yes.
And what was your understanding as to why she did that?
It was to protect the kids in case she was arrested, so she would be here to be available to turn herself in if needed.
Now, does the Gardner family have any homes out of this country?
No.
Any family that lives abroad?
Yeah, nothing abroad.
After, Miss Gardner, Shanna, eventually returned to Washington State after many months.
Yes.
What steps did the family take after she returned to Washington with respect to the possibility of her being arrested?
There was always a member of our family with her. In the event that she was arrested, we wanted to ensure that there was someone there with the kids, so that it would be as least traumatic as possible for them.
And did you perform that duty at time?
I did.
Did other family members do the same?
Yes.
Ma'am, there's been some talk about the daughter's baptism.
Yes,
Were you aware, well, let me ask this, are you a practicing member of the church?
I am.
And is most of the Gardner family a practicing
I'm
member?
surprised that this baptism thing is coming up as much as it is.
Most of us, yes,
And Shanna still communicated with you at all times, right?
all times.
And did Shanna speak to you about her daughter being baptized?
She did.
Can you tell the judge about those conversations?
She sent a text to us saying that AB had chosen to be baptized. And when I spoke to her personally, we were talking about that, and she said that she just wanted to make sure that AB was conscious of the choice that she was making, that she was informed, and that she supported her 100%. And as long as she had that knowledge, as long as Shanna felt like she had that knowledge, she was 100% on board, and even ended up buying the baptism dress for her.
As in Miss Gardner did? your sister?
Yes.
One moment, Your Honor.
Yes.
Yeah, I'm just really surprised. I'm really surprised that the baptism is coming up so much at this juncture, you know?
Ms. White, you heard the prosecutor talk about the significant resources that your parents have.
Yes.
Are those the same resources that they used to fly Shanna here after Mario had been arrested?
Yes.
And who paid for her to stay in all these Airbnbs and hotels for months?
My dad, Shelley.
And who paid to fly the kids down to see Miss Gardner during that period of time?
My dad, Shelley.
And is there a willingness on behalf of the family to invest the same?
Okay, so the reason they're asking this is smart, because they're trying to, I don't think anyone had any thought that Shanna had like her own money. I mean, she gets it from her family. But what they're trying to say is that Shanna herself doesn't have the means, the financial means to flee, like a P. Diddy, right? Like she couldn't just flee. That the reason she was able to move and try and do all these things, right, is because her, the parents paid for it, right? And so I bet what he's about to ask is, would they have the will? Would they want to give money for her to abscond justice and or something along those lines, right? But the idea is like, it's not her money, it's coming from the parents. And it's like, so I guess the idea would be like, Judge, if you can trust her parents to do the right thing, obviously she has no means to where she could flee.
Resources to make sure that if Miss Gardner is given a bond, that she
Okay, to invest, that's a better way to ask it. Rather than asking if they would give her money to flee, yeah, give her the resources so that if she has a bond, she can stay
will
there.
remain available to
Yep.
the court.
Of course.
Thank you.
That was a good
Those
question.
were the questions.
That was a good question.
Thank you. Cross.
Ms. White, has AB been baptized?
No.
Is AB, LB, and Ms. Gardner members of any ward in Washington?
No.
Isn't it true that your sister, Ms. Gardner, was actually very upset about the baptism dress? Because wasn't there a dispute with Kirsten Brighton over who was going to take AB shopping for that dress?
I'm not aware of that.
Ms. Gardner has been vocal to you and her other sisters about, at the time, her jealousy as to AB's relationship with Kirsten Brighton and becoming closer. Isn't that correct?
No.
Ms. Gardner was upset and annoyed that AB's baptism was going to take place at Jared Brightin's ward instead of her own. Isn't that correct?
I'm not aware of that.
Over the years, obviously, you were around when Shanna and Jared got divorced, and you would agree with me that it was a very acrimonious divorce.
Sure.
Your parents, in fact, don't like and did not like Jared Brightin, correct?
Are you speaking which tense?
Both, either.
I don't think they cared for the way that he treated their daughter.
And there was a lot of litigation, and your family was greatly involved in the litigation with Shanna Gardner about protecting her money from Jared Brightin during the divorce.
So this again just sounds like Adelson's, right? Like, it's interesting, because the thing is like before Donna was arrested, right? There was a lot of talk about Donna's involvement, right? Like Donna being involved in her children's life and controlling things or whatever. And of course, now she's, she should have already had her trial, but then there's that whole disaster with the attorneys and the conflict. And now she's still waiting for her trial. But, the meddling, right? Think about the meddling grandparents. And in that case, it was more about the custody of the children. And here it seems like it's more about the money, but still, it's just a weird other similarity. I'm not saying that they meddled to the same extent, but meddling at all and then getting involved at all is unusual. And already these cases have so many similarities. It's really bizarre. Now, if this is true, right? If the parents were meddling. And what I will say is this. It was after that trip to Hawaii. When we first heard about that yesterday, I thought it was a vacation just between Mario and Shanna, right? But it was that same week that they came back from Hawaii, that what it sounds like is there was maybe an ultimatum or something given, okay, that this has to happen now. But I thought to myself, because turns out it was a family vacation that they take every year. We learned that later on, that it was a family vacation. And I thought, I didn't say it, but I thought, oh, that's interesting, because the whole family was together. And so in the back of my mind, I was like, I wonder what happened there, because I don't know. I just found it interesting. So anyway. And the spinning wheel.
Divorce, correct?
I would not say that, no.
Ms. Gardner and Mario Fernandez are still married to this day, aren't they?
Sure,
Well, are they or are they not married?
I believe they are.
And Mario Fernandez was married to Shanna from 2018 till present, so he was in AB and LB's life for a while.
Correct.
And after Mr. Fernandez and Ms. Gardner separated sometime in the summer of 2022, he has not seen the children since then. Isn't that correct?
To my knowledge, no.
He hasn't been to the home of West Richland, Washington.
Not to my knowledge.
And you and your family members haven't spoken to him since then.
No.
Wait, I missed who they're talking about. Hold on. I missed who
Did
they're
Ms. Gardner?
Hold on, sorry. Okay, Mr. Fernandez. Interesting. Okay. That's why I was like, wait, who are they talking about? Because he's in custody. So, like, of course you haven't, I don't know. Let's see what spinning wheel. So was this the cold case one? The dude who was like really old, like 77 years old, did he get out on bond? Is that what that is saying? Oh, YouTube.
I believe they are.
And Mario Fernandez was married to Shanna from 2018 till present, so he was in AB and LB's life for a while.
Correct.
And after Mr. Fernandez and Ms. Gardner separated sometime in the summer of 2022, he has not seen the children since then. Isn't that correct?
To my knowledge, no.
He hasn't been to the home of West Richland, Washington.
Not to my knowledge.
And you and your family members haven't spoken to him since then.
No.
Did Ms. Gardner ever express to you?
I
or
pointed
other
this out
members of the family-
before. But one thing that is an oddity to me is that, that whole thing now, of course, this came from Henry Tenon, right? Came from Henry Tenon, that Mario told him, like, we have to do this week or whatever to save my marriage, something like that, right? My marriage will end if we don't do it this week, something like that, right? And we know, because we saw text messages, we saw communications that had to do with, like, whenever Shanna was, like, unhappy, like, both Kimmie and Mario, from what it looks like, seemed to offer to, like, kill Jerry. Now, who knows? Was it the joking thing? I don't know. But anyway, but it seems like something they would do, for her, right? But anyway, so this ultimatum, the thing about saving her marriage right now, I think what that means is the way I would understand that, if that's true, if that's what was said, is because Shanna would have said something like, possibly, like, again, if that's true, she would have said something like, either you get this done or I'm leaving you. Now, we've seen this in other cases. That's the thing, right? We've seen this in other cases. Do this or I'm leaving. And the do this can be different things, right? But in a lot of these cases that we watch, because they're murder trials, it's a murder, right? The ultimatum. So that's, I think that with the marriage ending thing, right? Because I was so confused about that initially. I was like, why would, like, Mario and Jared, they never met, right? So it's not like, because initially it's like, well, what, did they have some sort of weird thing going on? Like, no, they didn't. So the only motivation from what we know at this juncture, from what I know at this juncture, for Mario is just to basically appease Shanna, right? So basically, here's the thing that is weird that I still am just thinking about, which is that they separated anyway, right? Like, if they had these goals to save the marriage and they were going to do anything to save the marriage, whatever it was, doesn't matter, whatever. It's like, if the goal was to save the marriage and then they separated so quickly after the killing, something doesn't add up. And, it makes one wonder, does it have to do with the trust? Remember how there was that trust account thing? Does it have to do... now, remember, they're still married, but they're separated. So I'm just trying to remember. So I guess that wouldn't actually affect the trust. It's odd to me. I mean, one could look at this as like Shanna was just using him, you know, to get rid of Jared, and then once that happened, she didn't need him anymore. I don't know. It's interesting. I also think it's interesting the way she moved and became the literal next door neighbor of Marlow. I mean, is Marlow the new Kimmie? I don't know. I just have questions, basically. So
I think that she had concerns that Mario Fernandez was involved in Jared's death.
I never heard that.
She's never told you that?
No.
What about after Mario was arrested?
No.
Your family never had a conversation after her current husband was arrested for the murder of her ex-husband about his involvement?
No.
It just never came up?
I've never been a part of a conversation like that.
Your family has annual meetings, right, with minutes?
I see what she's asking.
Yes.
Did it come up at this year's annual meeting?
No.
The death of Jared Brightingham didn't come up?
In our last meeting, no.
Has it come up at any family meetings?
Not to my knowledge.
There was no conversation with Shanna Gardner after Henry
I
Taint
don't find that very plausible, unfortunately. I hate to say it.
was arrested for the murder of Jared Brightingham.
About Henry Tenon? No.
So before Mario Fernandez was arrested, before Ms. Gardner was arrested,
I just don't find that very believable, especially because I mean they were all privy, right? Remember, they're the ones that hooked her up initially with that PR firm, hooked her up with the first lawyer. I think hooked Mario up with his counsel, I think as well. Anyway,
Henry Tenon was arrested and publicly named as the individual who shot and killed Jared Brightingham, and Shanna Gardner never discussed that with you or the family members.
She never discussed it with me. No.
She never told you who Henry Tenon was.
She didn't have to. The media did just fine.
She never told you that she knew nothing about it. Or she didn't even know Henry Tenon. No conversation at all.
No.
Judge, I don't object, asked and answered and
Yeah.
beyond scope.
Yeah.
correct?
yeah.
I'll give some more light. Oh,
Has she ever spoken to you, and since you're the caregivers of the children, about conversations she's had with AB and LB about their father's death?
Could you say that again?
Has she ever spoken with you about the conversations she has had with LB and AB about their father's death?
Yes.
What has she said that she's told them?
Well, I don't remember anything specific other than, answering questions that they may have.
Like, how was Mario Fernandez involved?
I'm not aware of that.
Have the children ever asked her that?
I'm not aware of that.
As the current or part-time caregiver of the children, have they ever asked you that?
No.
The children have never once asked you about what.
Objection, Your Honor, asked and answered.
go ahead, finish, go ahead.
We didn't hear the
Children
rest.
have never once asked you about what you know about Mario Fernandez's involvement in their father's death.
I'll roll it. You can answer.
No.
Have the children ever mentioned Mario in the entire time since they've left the state of Florida?
His name has come up in things that they used to do with him. As LB has mentioned a couple of times, video games that they had played together. Beyond that, no.
You mentioned a memorial that Shanna Gardner and Mario Fernandez had for Jared Brightingham at your parents' beach house. Shelly Gardner, who's your stepmother, correct?
Yes.
She actually
I
published
called this because now again, remember, dude, they shouldn't ask that question, in my opinion, unless there's some reason I don't know about yet but the picture, the question about the photographer and whatnot. See, now this is giving them room to go into this, and they didn't bring it up. Well, I guess they couldn't have with a previous witness yet, maybe, but anyway, it hadn't come up, the whole thing with the photographer. So yeah.
those photos on her blog, So Shelly, correct?
Yeah.
And discussed the memorial on her blog, correct?
Yes.
And do you work for Stamping Up?
I do not.
Members of your family work for Stamping Up, correct?
Yes.
Stamping Up is the company that Shelly and your dad own.
Yes.
And Stamping Up released a letter about Jared Brightingham's death, didn't they?
Oh,
Yes, I believe they did.
so you can see
Despite-
again why we're then it's not all that plausible then, right? When she says that their family's never spoken about this at all, right?
The blog post about his memorial and the public letter released by her company, you're telling this court that no one in your family has ever discussed the murder of Jared Brightingham.
It's one of those things where it's like, and no one's going to believe that because that's not normal, right? Like, she'd be better off just saying, of course we did, honestly, because then she doesn't have to say, even if they ask her specifically, there's no way she would remember that, right? I don't know. I don't recall, but I know we talked about it. And then the fact that she said no is just giving fodder for this cross-examination on this.
For the involvement of any of the charged parties.
Have we talked about the murder? Yes.
I mean, but this is asked and answered though.
Have we speculated? No.
What have you talked about?
The fact that he was murdered?
murdering means at the hands of another you've never discussed could possibly have been the one to murder him?
No,
I don't have any further questions.
Redirect.
That's the court feed. That's the court feed.
Ms. White, was it a conscious effort by the family not to ask Shanna Gardner questions about her case?
yes,
Were you aware that she had retained an attorney in 2022?
I was,
And was the entire family aware that this was going on?
yes,
And was the family told not to discuss
That's
the
a
case
good
with Shanna
point.
Gardner?
we were
Good point.
told.
Good point. Now, having said that, she might do another recross. Here's why. That's a good point. But having said that, one of the questions that was asked of her is not just did you talk about it with Shanna, it's did you guys talk about it as a family without Shanna there? Because that is a difference. Like that makes sense, right? Around her, with her, right? Don't discuss it. But that there's no way that they can be told don't talk about this when she's not present, right? That has no bearing. So I wonder if she'll do a recross on that.
Good questions. Thank you, Ms. White.
Oh, it should be excused.
Yes, Your Honor.
All right, thank you.
Never mind. All right.
All right, how do y'all want to proceed? Going with document?
Yes, Your Honor.
Yes, Your Honor.
All right. Argument.
Well, y'all have competing motions.
Correct. I was gonna ask Mr. Curtis first, or whoever's in line.
I am, Your Honor. I'll defer to the state. I think.
All right, we'll have the state go first.
All right. State's
Okay.
going first.
And I do think it's their burden with respect to the Arthur hearing, because if they don't meet their burden, or if they do meet their burden, it's over.
Okay,
This court.
yes.
Derek Bridegan was brutally murdered, ambushed on a dark, desolate road with his 2-year-old child, strapped in her car seat, her face still sticky with ice cream after dropping his children off at this woman's house. Murder. The words used by defense witnesses have been done.
And by the way, in Florida, an Arthur hearing, that's a bond because they just referenced the Arthur hearing, that the state having an Arthur hearing. It's a bond hearing for defendants accused of non-bondable offenses. The purpose of the hearing is to determine if the defendant should be released on bail. So essentially what it means is when the judge denies bond, right? Then you can have an Arthur hearing to, ask for reconsideration.
Died his death, not for a robbery, not for road rage, not any action he did, but solely because he was an inconvenience to this woman. This was a cold, calculated, premeditated murder.
So to this question, so the bail bondsman, right? Like we heard about a little bit with Casey Anthony, I can't remember his name right now at the moment, but bail bondsman. They are the person that does that. That's how that's the difference between bail and bond. To post bond, you can't even do it through let's just say you're rich, okay? You can't just say, here's the money. That's not how it works. The difference between bail and bond is bond has to be from a secured bondsman, okay? And there's certain people that, and I don't know how they do it, but they get qualified and approved to be a bondsman, and literally that's all they do. So like for each, city or region, there's going to be a certain number, there's going to be like a list probably provided, certain bondsmans, right? And that's who you go through. So the way that someone posts that is not because they have that much money, right? Like that's the thing. So again, with a bond, it's the amount is almost secondary. The first thing you have to do is find someone who will be your bondsman. And what that means is this, okay? So they act as it's almost like a, how to say this? Like if you're gonna, okay. If you are gonna, how people will put their mortgage on it, for like, what's the word I'm looking for? Like for certain things, if you're gonna take out a certain loan, right? Or you buy a car, you have to like, what is the word? It's like assurance, right? You're like, okay, I'm going to put this thing on the line, right? Like if I don't pay this off, you can have the house, that type of thing, right? So, so it's kind of like that. Where like you have to have somebody, the bondsman, right, has to be able to like on your behalf say this person's going to comply with the conditions of bond. This person's like it's on me. Like in other words, it's on me if they don't comply. They're gonna follow the rules, this and that, and they basically vouch for you. And then they post a secure bond. Now, where they get the money, I have absolutely no idea. That's another question. Let me see if I can find an answer to that. because that is crazy, right? Now, of course, remember, if they, okay, so what they do is they make 10% payment from each one. So yeah, so the bail bondsman, they assume the risk of paying the full bail amount if the defendant doesn't appear. That's the risk. So if the defendant doesn't appear, they have to pay the full amount. That's why it's risky, right? So the money paid to the bail bondsman is separate from the bail itself. The bail bondsman is paid. Let me see here. So essentially, it's a non-refundable fee. So essentially, the way it works, right, is if you comply with the conditions of bail or bond, right, then the bond is, I think they call it released, so that it's like, it's a deposit, essentially. Like you have your bond amount, right? And the way that the bondsmen make money is they charge 10% of whatever that amount is. And the condition is that the person will show up to court, they will comply with all the stuff they're supposed to do. And if they don't, the bondsman assumes the risk of the full amount. Now, if they do comply, and then that's it, you go to trial and whatever, but you comply with all the conditions, then the rest of that money is released back to the bondsman. Now, the question I still have is, where do they initially get the money to start up this business? Because bonds are, but yeah, collateral, that's the word I was looking for. Thank you. That's the word. Thank you. Collateral. Yes. That's the word I was looking for. Collateral. Thank you. Yeah, they ensure you go to court. But it seems like, how do you get started? Like they must have they've got different associations they can become a part of. Now, having said that, the defendant does have to have the money to pay the 10% of whatever the bond is, like the fee. Now, do they pay that immediately? I don't know when they pay that, but that's how the bail bondsman makes their money. So they have to have that amount of money. So like 10% of like $35 million is still a lot of money. Wow, the practice of commercial bonds is unlawful in the states of Illinois, Kentucky, Oregon, and Wisconsin. Wow, there are 18 states where theoretically anyone can become a bail recovery agent. That's interesting. But in most jurisdictions, they have to be licensed. I think that's the case here where I live. Some insurance companies may offer insurance that includes local bail bonds for trap. Well, that's funny. Wow, Nevada is one of the states that allows an arrestee to use a residence as collateral for the bail bond. Yeah, that's interesting, isn't it? So that's, instead of, if you don't have the money to pay the 10% or whatever, you can use your residence as collateral. So this is like double collateral, like all the collateral in this situation. Wow, interesting. Now, if the defendant fails to appear in court, then the bond agent must bring them, and they might employ a bounty hunter. Oh, this is funny. Some states, such as North Carolina, shout out to North Carolina, have outlawed the use of licensing of bounty hunters. I think that's a good idea. Requiring instead that bail bondsmen apprehend their own fugitives. Bond agents may also attempt to recover money forfeited to the court for the failure of a defendant to appear by suing indemnitors, which is any persons who guarantee the defendant's appearances in court or the defendants themselves. So again, there's like other people, like in other words, there's like other people who assure they're going to appear. Wow. Interesting. Anyway, so now there are alternatives, it says, that can be determined by the court. Okay, but so that's what we're talking about here with this bond. Right. So the only question is like, sort of like, do they have to go hunt them down themselves and return them so that they can get their money back? Or do they bring someone else in North Carolina, right? They can't use a bond. They themselves have to bring the person. That's interesting that you watch those shows. I didn't even know that existed. That's crazy. So yeah. So I'm just wondering, do they get started? Like, where do they get started though? Because like, you'd have to have the money from the beginning, right? Like to start up that business. Like you'd have to be like, yep, I've got like Maybe you start small, but even still, it's probably like $10 million. I don't know, right? A lot of money. Like, you know, like you have to be able to front that first one to get the first fee. I'm just thinking like in terms of the business model, like, you know, how you start that up. Interesting.
Following years of plotting and planning, manifesting, hoping, wishing, making it happen, seeking, enticing, inciting, encouraging. Shanna Gardner was not present on the scene. Nobody is saying that. She went to Walmart, she went home. There are no direct text messages that the state can find or ever will find because she planned this murder with her current husband, whom she lived with. The circumstances and the circumstantial evidence in this case weigh so heavily in pointing the finger at her as the person who set this entire event into motion.
So that's
over
interesting. So it sounds like the state just admitted they don't have, oh boy, that's big. Did you guys catch that? It sounds like the state admitted they don't have communications between Shanna and Mario talking about this. So what they've got is this. Interesting. They've got Shanna talking to Kimmie, right? Which honestly, it really did look like it could be a joke. Some of it was more damning than others, right? That's going to be something for the jury to decide how they interpret it, right? But like the thing about like, I could just kill Enterprise. Like that's not even a person. So like, you know, there's some really, we talked about that yesterday, right? So like there's her joking with Kimmie or talking to Kimmie, depending on how you view it. And then there's Mario like talking to Henry Tenon and like, then there's the money. But they don't have any communications between Shanna and Mario. I wonder if that is why they've not made a motion to sever, because that right there would mean that is a detail that is really important. Because if they don't have anything about the two of them plotting this together, there's no way to throw them under the bus unless it's with the defendants taking the stand, right? In other words, it wouldn't make sense for Shanna to try to throw Mario under the bus or vice versa if they don't have any proof that the two of them talked about this ever. That is a big deal. That is a big deal. That is a big deal. Now, having said that, that being the case, I mean, that being the case, right? Like I said yesterday, in a lot of ways, just from like practical purposes, this does look worse for Mario in terms of, remember, like I said, you have to actually prove that they hired him, right? Well, we know that Mario like was writing the checks because he had control of the trust. You got to think about that too, right? Like the timing of it, right? That Shanna puts the trust in his name so that she could evade having to make payments or whatever with Jared. But also by doing that, you know what it means is that it kind of makes it seem like it's Mario that's paying Henry. So like, while she could have planned this whole thing out, again, the direct evidence, you know, or well, it's not direct evidence, but the physical evidence, right? The physical evidence ties Mario more to it than her. So with that being the case, though, you could see that it could be advantageous for Shanna to try to throw him under the bus in a way, right? Like, I didn't have anything to do with it, you know? But at the same time, we don't know what all the statements they made. And the statements they made seemed to be like, we were both together at home. And so some of that stuff that happened early on might be why they don't have a choice but to stick together. You know what I mean? But also, if the state doesn't have any evidence of the two of them working together, again, if that's the case, then it seems like the thing you would want to do if you're the state is try to really hammer hard the Mario connection to Henry. But then, yeah, it's interesting. It's interesting. Strategy here is really interesting from all parties, because this could go a lot of different ways. And it is, again, it's just so unusual that they're not being tried separately. Like, this is really different. But the fact that is so far of all the mistakes that these defendants have made, you know, like self-snitching, thank God, like the one thing that they've done right is not communicated apparently in writing, unless some of those are the deleted messages. But she actually says that they just did it all verbally in person because they were living together. So that's kind of a big deal. She's not saying, oh, we think they communicated and deleted it. So that is the one thing they did that wasn't dumb, you know, I think so.
Years. Based on this idea that she was fixated on, that she wanted freedom from Jared Brightigan, freedom to do what she wanted with the children, freedom to be in charge of her own trust, freedom to make decisions about their therapy, their medications, their religion, where they would live, what they would
Well, she could have, so I'm going to push back on that because she could have been in control of that trust. That was her decision to put it in Mario's name.
do.
And honestly, to just again, to push back on her argument would almost suggest that if she wanted to be in control of her own trust and it was in Mario's name, that she should have killed him. So that doesn't make any sense. Actually, I can push back on all this. Hold on, let me back this up so I can argue with her. Because it's fun. Oh, spinny wheel. She rattled it off quickly, didn't she? What she's listing out is basically what she thinks is the motive, right? So let's just.
She was fixated
Okay.
on that she wanted freedom from Jared Brightigan, freedom to do what she wanted with the children.
Freedom to do what she wanted with the children. Well, again, that's kind of vague, but like, are you meaning custody? Because as we saw, that was not an issue. It seemed more about the money.
Freedom to be in charge of her own trust.
Okay, the trust. That one doesn't make any sense because again, it was in Mario's name and it was Shanna's choice to do that. My understanding was Shanna was the one who was still in charge and could put it back in her name whenever she wanted, but that she chose to put it in Mario's name because of the payments for the children, and that her plan was to put it back in her name after he was gone. Regardless of what her reasons were, she still was in control of that. But even if she wasn't, this makes no logical sense because again, if Mario was in charge of the trust, which again, I don't think he was, but temporarily was, then wouldn't your argument, Ms. Stifler, mean that she should have killed him?
Freedom to make decisions
In other words, Jared had no control over that trust. So that makes no sense.
about their therapy, their medications, their religion, where they would live, what they would do, when they would do it.
Okay. She rattled things off really quickly. I mean, we know they fought over that oxygen tank. I mean, we know they quarreled over petty, stupid things. So we pointed that out yesterday because I was like, that is really stupid. Like of all the things, right?
Despite the myriad of other alternatives available to Shanna Gardner, a woman of her resources, her education, her influence, and her power, she chose murder instead of the court system, instead of the legal system.
Yeah. Again, I think that Shanna's case is better than Mario's. And again, I'm just pointing it out as I'm thinking this through because again, the checks, right? And it's still up in the air if Mario was driving the truck. The state says Mario was driving the truck. I said that doesn't make any sense because why would he be driving the truck? What was the point of hiring somebody if you don't have an alibi, right? And I think that, again, I think the state is saying that only because they got that statement from the kid who was like, oh, they're trying to say he was unsure. And again, I said this yesterday. I don't think the kid was unsure. I think he thought the question was more about, was he playing a video game? Not was he there in the room or there at the house? And so, because it makes no sense. But from what I understand so far, there's no eyewitnesses, I don't think yet, right, that put him in that truck. So it's really kind of imaginary. But whether he's in the truck or not, the one thing that's undeniable is those checks, right? And the other thing that's undeniable, I think, is they've got that phone call, right, that Henry calls Mario immediately when he's arrested, or the friend does, right, on his behalf. So in other words, again, when you look at why am I saying this, right? I'm saying this because Henry has pled guilty. Henry has pled guilty. So whoever connects to Henry more is in the worst position of the bunch, right? So what you won't want to do is have any connection to Henry, which is why to me, it almost looks like if Shanna's involved, it puts Mario as like the middleman. Again, like a Katie Magbanoa. Like to me, if all this is true, is what's alleged, Mario is the Katie Magbanoa. He found the hitman for someone else. That's what this is. But that's why it's so crazy that they're being charged the same. And I'm just like, what is happening? Because really, and it almost makes you wonder, had they charged Mario with not that, would he have been more likely to take a plea deal? Because that's what you want to do, right? If you're the state, that's what you want to do. You want Mario to have some incentive to plea and throw Shanna under the bus. Like a Katie Magbanoa, right? Because if he's the middle person, that's what you do, And again, there's just no reason for, anyway, I feel like a broken record, but it is very interesting because the way that they've charged him is really interesting. And then the fact that, everything is really circumstantial as far as Shanna being tied to this, right? Like from what we've seen so far with the evidence. because of the fact, like that's incredible that there's no communication between her and Mario. I mean, that is the saving grace for one or both of them. I don't know who yet.
The state of Florida and the law enforcement officers
Yeah.
worked tirelessly on this case for years and years and years, not only
Thanks.
established evidence of this woman's guilt, but they eliminated every other viable suspect in the state of Florida, certainly practically on the face of this planet, that would have any reason to target and ambush Jared Brady. Because again, this isn't road rage, this isn't a gang initiation, this isn't a drug deal gone bad, this isn't an affair or a drug debt or a beef with somebody. This was somebody hiding in the woods on a dark night, waiting for this man to move a tire from the middle of the road and gunning him.
But who did that? Is she confused? Is she confused? See, again, this is the thing. If this is, picture this, guys. If this is what they're arguing, this is somebody who was waiting in the night to gun him down. You're talking about Henry Tenon. That's not up in the air. That's not up for dispute. He pled guilty. Now, of course, people can plead guilty to things they didn't do. But again, we're assuming he pled guilty because he did it, right? You're talking about the wrong person. You're making the argument to the wrong. I mean, this doesn't, like, that doesn't even work for Mario because Mario didn't gun him down. Anyway.
Him down in cold blood while his daughter sat in the car seat covering her eyes with her jelly shoes. And
the argument she just made, honestly, is the argument for why you shouldn't give him a 15-year plea deal, right? For Henry Tenon. The argument she just made is how he could be a future danger to society. Henry. But that is the opposite of where she's at, because where she's at is he needs a 15-year plea deal where he can get out. And also, the people who you're talking, like the co-defendants here, are not the people that did that thing. So this makes no sense.
To look at in this case is the circumstances surrounding this. She was her own worst enemy and her own greatest witness against herself because she was so vocal for so long about wanting this to happen.
I mean,
about how much.
Again, the self-snitching. That's why I was shocked. I'm like, at least she didn't have this in writing with Mario, because the Kimmie messages is so much.
Hated Jared, and the people she spoke to about her plan are people that she thought she could trust that
Yeah.
would never take the stand against her.
I literally was just going to say it's only specific people. It was only specific people. So, for example, her other friend Marlow didn't have this whole jokey thing about killing Jared going on. That whole dynamic, right? That dynamic she had it with apparently two people that we know of, which was Kimmie and then Mario. But again, she's saying it's because it's people she could trust. If all this as alleged is true, I don't think that's the case. I think she picked people who she thought, if she did it, right? If she's involved, I think she picked people who she thought she could manipulate into doing it for her. Again, I've talked about it before, but we've seen this in a lot of cases where they pick people who they think will do anything for them. You know, again, think about what it would take to get somebody where you complain about your ex spouse, especially when they're not abusing you, right? There's no physical threat, right? Because sometimes we see people make that up too, right? To get people to act. But she didn't even do that. She's just like not happy about it or whatever, right? And again, complaining about the money, but like the money's not really an issue. It's only an issue because you're making it an issue, you know? So like, it's not like, in other words, it's really just like petty emotional stuff, but it's not like there's any actual, not that there's ever a reason to kill. But my point is this. Think about how much more manipulation it would take to manipulate a friend, a boyfriend, a husband, whatever, somebody, into killing another person, especially when your life is not in danger or there's not, you know what I mean? Like, while there's never a good reason to kill, this one takes the cake for maybe like literally, how did you convince somebody? Because like, you can't even make something up that's a good enough reason. But that my point is this. The only reason isn't because Jared did this or that. The reason would be to make Shanna happy. That's where the different level potentially of this manipulation or with these specific relationships would come in, right? Because we kind of saw evidence of that in those text messages. There are some that were really pretty interesting, you know? But I'm just thinking this through because, again, this is really interesting in the sense that with Shanna's involvement, it's entirely circumstantial. Entirely circumstantial. Like, it's really circumstantial. Like, super, 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 super circumstantial. Now, the only exception to that is Henry. But again, the thing, wow, that's so interesting, right? So because eyewitness testimony is direct evidence, right? But anything eyewitness testimony that Henry's going to have would pertain to Mario. Because from what we know so far, him and Shanna never met, except one time they maybe waved to each other years ago or something, but they never met. So again, wow, like there's no direct evidence as it pertains to Shanna. So, wow.
People she thought wouldn't be believed. It is not easy to find someone or hire someone or solicit someone to
Right.
help someone. There are
I
no
know.
yellow pages for
That's
it.
right.
There's no attorney she can call them.
That makes no sense.
Someone to refer her like they referred her to an Airbnb to hide out to before she surrenders herself. The people she asked were people that she knew. A trainer from a gym that I had an affair with. Tattoo artist. And
And having said that, if she continues like this in the trial or Mr. Mizrahi, you know what? I hope they do. And you know why? Because that is a huge gift for the defense. Because the defense is going to, I would be laughing. I would be laughing. I'd be like, did you hear what she just said? You heard from Henry Tenon. He pled guilty to pulling the trigger. The state is the entity that made that deal with him. And you know, when he takes a stand, they're going to have to talk about that. They can't, they're going to have to explain, imagine this. They're going to have to explain to the jury that he has an incentive to say things that are beneficial to the state. So there's that. But anyway, it's like, you heard him. The state is the one that offered him this deal where he admits to pulling the trigger. So then, and now the state's coming up and saying, or suggesting that Mario and or Shanna pulled the trigger when they already have the person. Like you see it, like you see what I mean? It just doesn't make any sense. So for the defense, honestly, go for it. Make all your shitty arguments that are full of logical fallacies and get ripped apart. You know, you deserve it.
Tenant of my husband who has a criminal record, people that she in her mind believes to be involved in the criminal justice system, the only people in her circle, in her world that she thinks without any kind
Take a step further. Ladies and gentlemen of the jury, if the prosecutor is willing to exaggerate, and this would be like a closing argument, right? And to flat out lie to you about who pulled the trigger when they know who pulled the trigger. We know, you heard from him yourself. We know who pulled the trigger. They're willing to lie to you about that when you already heard who pulled the trigger. What else are they willing to lie to you about so that you will convict these innocent people? Something like that.
knowledge about doing this type of activity because everyone else in her world is equally educated, equally influenced, equally affluent, and not involved in this corner of life. Her own words,
You know what you can do. See, if they make those types of mistakes, doesn't take much to get the jury thinking that the state's hiding the ball. And I've mentioned it's just like with Casey Anthony and others. When the jury feels like the state is lying to them, I don't see how you have anything but an acquittal, to be honest. So really, regardless of what evidence they have, the state can fuck it up for themselves. Really, they can fuck it up as long as you've got. All it takes is for, again, even with Casey Anthony, we haven't gotten to closing arguments. We're just about to start the defendant's case in chief, but the state did it to themselves with that exhibit 313. The state was hiding the ball and the jury noticed it. The defense didn't have to do a damn thing. The jury noticed it. Again, you're done. You're done. State, you're done, right? You're lying to the jury. You're trying to lie to us. You don't want it. It's your evidence and you don't want us to see it. Are you kidding me? So I don't think a jury is going to forgive the state for that. Honestly, I don't think any jury would forgive the state for willfully, intentionally lying to them or hiding things from them. I don't think that's possible. So.
and her actions preceding this homicide and her actions after this homicide are the proof evident presumption great of her guilt. We filed a motion to deny her bail under the Florida Constitution and Arthur, as well as a pretrial detention statute. We have met our burden today.
Okay.
We presented live testimony. The state of Florida
Okay, so they filed a motion to deny her bail. So in other words, for whatever reason, she wasn't automatically denied bail. I don't understand how that works because first degree homicide, my understanding is like that's automatically non-bailable. I'm trying to think, what state was it? No, that was Pennsylvania. Because states have their own rules, but Florida, anyway, so they filed a motion to deny bail. I'm just surprised. See, my thought was that she was automatically denied bail, and this is them trying to make a motion to, they object to that, right? Like they're saying, judge, motion to grant bail, right? But this started with the state making a motion to deny bail. That makes me wonder with Mario, was he automatically just denied bail outright, or did they go through the same thing, but they just didn't have a hearing? I don't know. Interesting.
Florida could have presented affidavits, put our detective on the stand to prove that heightened level, that heightened burden with a heightened presentation of case, subjecting him to cross-examination. And we have proved that she has committed the charges against her as a conspiracy to commit
Well,
first
and
degree
remember,
murder.
Judge Kite even referenced that they've got two motions happening at once. So as far as the burden, it's kind of two things, right? In other words, this hearing is dealing with these two motions. The first motion was the state motion to deny bail, right? Now, if they were hearing just that in its own hearing, right, it would be the state's burden to prove she doesn't deserve it, right? However, this is kind of similar to like in civil trials where you have a lawsuit and a countersuit, kind of like that, where you're proving both at the same time. That's kind of what we have here. So you've got simultaneously then the defense filing the motion to grant bail, motion to deny state's motion to grant bail. And so then again, if that was being held separately, they would have the burden. So this is kind of a funny thing. And that's why I think Judge Kite was like, who wants to go first? Because it's not really clear. That makes sense now. I didn't realize the state had filed a motion first. That's interesting. But that's where they had the burden to prove that she was bad enough. And that, I guess, is what the deal was with their witness, right? And then that's why we saw the defense witnesses that are like, we're showing you she won't flee. We're showing you this and that, the other thing. Okay.
Solicitation to commit first degree murder as a principle to first degree premeditated murder, as well as a principle to child abuse. The principal instruction in Florida is just that she had a conscious intent the death did occur, and that she did some act or said something that was intended to and did incite, cause, encourage, assist, or advise other people to carry out this homicide. And again, she had no dealings directly with Henry Tenon. There are no communications the state of Florida
You
has.
just said that. Hold on. Let me back that up. This is my point. Dude, she just said it.
Incite, cause, encourage, assist, or advise other people to carry out this homicide. And again, she had no dealings directly with Henry Tenon.
Now, she had no dealings directly with Henry Tenon. Now, we know that's the purpose, right, of hiring a third party. She had no dealings with him directly. But what does that mean? That also means that makes Mario the middleman, literally. I just don't understand what's going on with this charging decision. Because really, if you want, like, this doesn't make sense, right? It doesn't make sense. The way that they're charging these two people doesn't make any sense to me. Because the way that she's separated from Henry, that is the whole thing. That's why you have a middleman. Anyway, so in other words, if they want to say that she's in charge, they have to put him as the middleman. I don't get it. So essentially, again, she had no dealings directly with Henry. Okay, I'm trying to explain this. So that right there would benefit the state if they were trying to argue that Mario was the middleman and if they were charging him that way. Because that's the whole scheme, right? When you hire a hitman, it's identical to the Adelsons, okay? When Katie McBonneau was the middle person. Charlie, right? I mean, I'm not going to go back to my theories of all of that, but as far as what we know, who's been arrested already, convicted, Charlie, he's going to get a new trial, but Charlie talked to Katie and said, Katie, can you find somebody? And Katie went and found people, right? And all those people already, pled and all that, right? Katie was the middle person. The whole point was so that Charlie would never have any direct contact with the hit people. It's identical to this. So in other words, the fact that Shanna had no contact with Henry, if you want to get Shanna, what you have to do is say, because okay, my point is this. The fact that she had no direct contact with Henry, that can be beneficial for Shanna, right? How is it not beneficial? The only way you make that case that the reason she didn't have any direct contact with Henry, that was on purpose. The only way you can make that argument to a jury is if you say, because there's a middle person. Do you see what I mean? They can't make that argument if they're not calling him the middle person. So in other words, the way that they're charging this actually makes Shanna, this is my point. This actually makes it seem like maybe Shanna had no involvement because of the way they're charging this. Them saying she had no dealings directly with Henry, right? But yet there's not a middle person. What that makes it seem like is it's Mario is the guy, right? Does that make sense? I hope I'm explaining that correctly, because this is, and trust me, the defense is going to be all over this. I think the state needs to choose. I think they need to choose. They need to either completely change this whole thing. They need to reduce Mario's charges, and they need to put him as the middleman. And then they can come in and say, Shanna was the mastermind. She planned the whole thing. Now, in other words, they would argue the evidence that she is involved and that she planned the whole thing is because there's no evidence she had any dealings with Henry, but Mario did. That's the whole point, right? Or if you keep it as is, what you're making it look like is that she didn't have any dealings with Henry because she had nothing to do with it. Right? Because you can't use the middleman excuse if you're charging Mario the same as her.
There are no communications the state of Florida has, or even if we had, that we could use at trial between her and Mario Fernandez because they stayed married to this day.
You guys see what I'm saying?
What we have is a tremendous circumstantial case against her based on her words,
Literally what I was just saying.
her
Entirely
actions,
circumstantial.
circumstances that she incited, because we will never have direct evidence of that.
If you're saying she incited it, Mario is the middleman. What are they doing? Literally.
Mario Fernandez Aldana decides to become state cooperator. Those being that this woman is the only person in the world that had this level of resentment, hatred, and motivation to ambush.
So Matt, I don't understand. I don't have any way to think of Mario being the mastermind. The only thing that could get me there is there's no evidence of this. Okay. This isn't an alternate reality as that my brain is working on this like an exercise, right? The only way I could get to Mario being the mastermind is if, remember how he made that drive after the murder? What I was thinking, they talked about him going to Canada, which he didn't do. And anyway, I don't know what that was. Maybe it was to get rid of evidence. I don't know, allegedly, right? The only way I could get to Mario being the mastermind is if he had a plan without Shanna. Like Shanna's playing him, but he's playing Shanna. And the reason would be because his name was put on that trust. The only way I can get to Mario being the mastermind is if he fled and left the country after the homicide and ran off. And now she can't do anything. And now that trust is in his name. That's the only way. Now, none of that happened, right? That's the only motivation. That would be his name on that trust would be the only motivation for him to be the mastermind, unless he's just trying to make Shanna happy, which does not make him the mastermind, right? So what I'm saying is you have to separate mastermind, right, between who actually did the thing or is more connected, right? So my point being that the case that the fact that everything is circumstantial against Shanna, that actually would almost, again, that makes you look like the mastermind, right? That's the person who hired, that's the person who has a middle person who to go hire people, right? She did the same thing with Kimmie. Remember, Kimmie was like, had to go talk to Sue. Same thing. Kimmie is Mario. They're like one and the same. She's like talking to Kim. Look at that. Look at that idea, right? Shanna doesn't go find somebody herself, right? Allegedly. She has someone else go find someone. That's a middle person. So that way, when something happens, you're not connected. That scheme is a middle person. And I'm so surprised the state's not going with that, because they could use this whole thing with Kimmie and Sue to back that up. That would be a rock solid, like, honestly, because the thing is that an entirely circumstantial case makes more sense when you're running it through this whole thing of they did everything to keep themselves distanced from the person who did the act, which is right. That's the whole scheme. So like they lay that out really well with the Adelson case, right? That everything that they did was to remove themselves from the actual people who did the thing. They didn't ever talk to them. They never met them. They didn't know what they looked like, but the middle person did. The middle person is the contact person, right? So, and the way you get to the top dog, right, is you get to the middle person and you cut them a deal. So again, the mastermind and then the person who actually gave the most evidence against should be two different things. Like, in other words, they have more evidence that Mario had contact with Henry, right? That's clear. That doesn't make him the mastermind. That makes him the middle person. The circumstantial element, all the circumstantial stuff with Shanna, that would make her the mastermind. Does that make sense? Yeah, I don't know. People don't make any sense. Like, there's no way. I don't see how you get to Mario being what. Like, did they cite any reason for this? Like, what would be his motivation? The only thing I can think of is that trust, and that only works if he like absconds, right? And like can drain the trust and abscond, and none of that happened. So, I mean, he could have tried probably, but I don't know. Maybe he didn't. It doesn't matter. That's completely theoretical. That's like, but again, that's the only motivation I can think of to make him the mastermind. And then remember the other thing, see, whoever thinks this, I don't know, man. The other thing is that we have all these text messages between Shanna doing the same thing with Kimmie years before she met Mario. That right there. Jealousy of what, though? Because it sounds like her and Jared hated each other. That doesn't make any sense. Unless she had some other, did she have another? No, that wouldn't. I was going to say, did Shanna have another boyfriend? But that doesn't make any sense because he would kill that person and not Jared, right? Like the killing of Jared doesn't make sense in terms of jealousy because Shanna and Jared seems like they hated each other's guts. There's no, like, you can't, there's no evidence of that yet anyway. Yeah. I mean, it does sound like there's been whispers, sprinkles, if you will, of Shanna having cheated on Jared, but it doesn't seem like there's any whispers of Shanna cheating on Mario yet.
Eliminate Jared Bright again. That she wanted to have total control and freedom over the decisions in rearing their children. That she spoke at her interview with Jacksonville Beach Police about her resentment for how he was during their marriage, and some resentment for how she felt that he was acting now. As you know, now he's turned the corner. Now he's the perfect husband. Now he's the perfect father. And that freedom, that motivation is evident.
They should have gone with second-degree murder for Mario. You know, it's funny because I think that's what they initially charged Henry with, right? And then they talked it down into like nothing. Like that deal is the deal of a lifetime. But if you know what it ends up being is some sort of crazy. They walked that back. I can't even remember what all they walked it back to. They walked it back to where it's 15 years, and he'll have time served, right? So if he does what they want him to at trial, you know, he'll be out in like 12 years or something. You know, what they ought to have done is then charged Mario with like the second, in my opinion, right? Like the second degree and like maybe solicitation. I just think they shouldn't have charged them the same because I don't think that it doesn't make any sense. It just doesn't make any sense. Their theory does not make any sense with the way they charged this.
Based on where everybody ended up, because Henry Tenon, no doubt, pulled the trigger and killed Jared Bright again. He's confessed to it. He says he did it.
So there she goes contradicting herself. Because wait, I thought you were saying that Mario and Shanna pulled the trigger, waiting in the night and all that nonsense.
He says Mario Fernandez solicited him, paid him, provided the firearm, drove him there, was on scene when he murdered Jared Bright again. There is no motivation for Henry Tenon to do this crime without being incited, encouraged, or assisted by Shanna Gardner and Mario Fernandez.
Okay. But that seems plausible, but is there any evidence of that? Like, is there anything to suggest that? I mean, maybe I don't know what it is yet, right? But like, is there like I don't know, is there an instance where they got in a fight, Mario and Jared? Or did they have some nasty text messages back and forth? You know, like there has to be something, right? To like, because I thought from what we've heard so far, they didn't really ever meet, right? Like, because remember Mario even like, that whole thing about Mario kind of pseudo stalking him allegedly, where he would follow him around and get close. That would almost indicate that Jared had no idea what Mario looked like, but Mario knew what Jared looked like, right? I don't know. Oh, speaking. Like, yeah, it definitely seems like they never met. From what we've heard so far, and that they never had any contact. So their only thing in common is Shanna. Their only common
incited, encouraged, or assisted by Shanna Gardner and Mario Fernandez. And there is no motive for Mario Fernandez to do this without the encouragement and solicitation.
What are you talking about, ma'am? Y'all. She's saying what I've been saying, but the problem is what she's saying makes no sense with the chart. Let me back this up. This is what I've been saying the entire time. Hold on.
Being incited, encouraged, or assisted by Shanna Gardner and Mario Fernandez. And there is no motive for Mario Fernandez to do this without the encouragement and solicitation and permission of Shanna Gardner.
You can't have both. If that's what you want to argue, and if that's your theory of the case that you're going to take to trial, then you cannot charge Mario the same. Are you joking me? What are they doing? If I were Mario's defense team, I would be having a field day. And if I were Shanna's defense team, I would be having, I would be having a field day with this. I'm like, great. Let's not, you know what I would do? I'd be like, I don't want to let on what a terrible argument this is. Like, I'd be like, let's keep it to ourselves. Don't say, don't show her that you're like having Christmas right now. Let her go with that and then bury her with it,
The most damning evidence we have comes from Shanna Gardner's own statements to her best friend, a woman she trusts with her life, a woman she talks to 5 or 6 times a day, a woman she tells the most intimate, mundane details of her life, a woman that tagged herself.
Now, the other thing that baffles me is why the fuck is Kimmie not charged? I think that is as clear as anything else.
Quote, Team Shanna, a woman who was dragged to grand jury, was withholding, minimizing, refusing to tell police about
everything she's saying. What is wrong with this lady? Everything that she's saying, withholding, minimizing, refusing. Everything that she's saying is why Kimmie should be charged. I don't know.
Text messages, all because she wanted to protect her best friend. The statements that she did give the state of Florida and law enforcement, likely just the tip of the iceberg of what this woman actually knows.
You can't just speculate and make things up, lady.
And she wasn't bullied, she wasn't threatened, there was no show of force suggested in defense cross-examination that we put her in a patrol car, put a bunch of posters in front of her face and made her tell us what we wanted to hear. What she told us is in black and white in these text messages. She said it at the grand jury under oath, and she said it again. And she's going to say it on that stand at the trial. That days before Jared Brightigan was ambushed, targeted, murdered with no other suspects and no other motivation, that this woman sat across from Mario Fernandez in Hawaii and told her, if you really don't want me to do this, you need to tell me now. The evidence that she said yes is so overwhelming because the ultimate result, the consequence speaks to the action. He would not have done this. He would not have gone to Henry Tenon, given him the gun, and done this.
I need to back it up because I wasn't listening. I was thinking. The whole thing with Kimmie is just so weird. So because to this question, right? Remember what I said, right? Because she could, what is she going to say? Here's what I can see. No matter what is going on with Kimmie, when they're questioning her about the text messages, the state's going to be asking her, when it comes to the defense, right? There are so many of those text messages that are Kimmie saying things like, I'm going to kill so-and-so. I'm going to kill so-and-so, right? Kimmie, there's a lot of those damning text messages came from her. And what's going to happen is when the defense asks her about that, she's going to have two options. She's going to either say, yeah, we were being serious but then that would make her serious. And then the follow-up would be, well, did you kill your kids? Did you kill your whoever? She's either going to have to say, yeah, that was serious, or it was a joke, right? I don't know how this is going to work for the state, because the thing is there's no way, like literal, there's no way those text messages were meant literally every time. There's just no way. There's no way. So the state is either going to put her up there and they're going to have to concede that those text messages were a joke, in which case then Shanna probably is going to be going home, right? Because I would say those text messages with Kimmie are like the most damning thing against her probably so far from what I've seen. Or the other option is to be like, yeah, they're definitely not a joke. You guys were being serious. So how many bodies do you have buried in your backyard, basically, right? You see what I mean? I don't know how that's going to go, but I do know that no matter what, there's a lot of problems there. And in other words, if Kimmie tries to get up there and say that was all serious, there's no way around it. You know, she's lying, right? And why would she be lying for the state? So I don't know about the immunity. I have so many questions. I talked about this a lot yesterday about what could be going on there. I don't know if what happened was there was a Brady violation when they talked to her. It sounds like that could be the case. And because of that, when they interviewed her and they put those text messages on the wall, remember, that sounds like a custodial. That was a custodial interrogation. It sounds to like that right there makes it sound like they were planning on charging her with something. And there's no proof. There's no evidence that wasn't recorded. Remember how weird that was? There's no recordings. That whole thing just disappeared and there's no charges. It makes me wonder if there was a Miranda violation and her attorneys, they in other words, everything's fruit of the poisonous tree and they couldn't bring any charges against her. That's what I'm wondering. Something like that. Because even with immunity, the immunity would be you get a deal. Like there's no way that she's not charged. And I looked her up in the docket. I looked her up in the docket because even if they had charged her with something minimal, right, and cut her a deal, she would be there. She wasn't there. And so she wasn't there. So they didn't charge her. So are you saying we'll learn later more about Kimberly? Yeah, this is one of the biggest mysteries I have right now. Is about Kimberly. So, yeah.
Our bunch of posters in front of her face and made her tell us.
Here it is with the posters in front of her face.
What we wanted to hear.
Made her tell us what we wanted to hear. That sounds like a legit hardcore interrogation, like hardcore.
What she told us is in black and white in these text messages. She said it at the grand.
And that's incredible. It's incredible that she's like, there's a lot of admissions. There's a lot of admissions in what she's saying.
And jury under oath, and she said it again. And she's going to say it on that stand at the trial. That days.
It sounds like they're threatening her. That's what it sounds like.
Before Jared Brightigan was ambushed, targeted, murdered with no other suspects and no other motivation, that this woman sat across from Mario Fernandez in Hawaii and told her, if you really don't want me to do this, you need to tell me now. The evidence that she said yes is so overwhelming because the ultimate result, the consequence speaks to the action. He would not have done this. He would not have gone to Henry Tenon, given him the gun, and done this action if she hadn't said yes.
Lady, dude, she is laying out exactly the reasons I said why Mario is a middle person. So the thing is right, these are co-defendants, right? Everything that she's saying, if she wants to make this argument again in front of a jury about Shanna, then how is she also going to argue that Mario is just as culpable? It's not possible, right? Now, if they were severed, she probably could do that. Right now, there's ways around it. They can bring things in, right? Like, it could still be problematic. But if she wanted to be able to argue that Shanna's the mastermind and blah, blah, and she wouldn't, and then go and argue like the same thing about Mario, like that would work if you had two separate trials with two separate juries. You'd have a better shot at that, right? Kind of like with Chad and Lori, right? They were able to show that both of them were really equally as culpable. Now people, just for fun, kind of still try to talk about who's the mastermind, but I will say in that case, I do believe they were equally as culpable, regardless of who's the actual master. They were equally culpable. And I don't know that that's the case here. But regardless of what I think, what she is saying is Shanna was the mastermind. And like, look at this shit. This is insane.
Overwhelming, because the ultimate result, the consequence speaks to the action. He would not have done this. He would not have gone to Henry Tenon, given him
He would not have gone to Henry Tenon.
the gun and done this action if she hadn't said yes. Because
I don't have any more words.
in the end, she got what she wanted.
This is
She
insane.
and Mario
This
Fernandez
is
stayed
insane.
married, but
If I were Mario's attorneys, I would be like filing a whole bunch of shit after this. Like, what are we doing? She's outlining literally how, like, there is no way to charge him with first. Like, how do you do this? Like, how do you get?
they went their separate ways. She got control of her trust. She got to move to Washington. She has her children. No one's interfering with her now. She's got even her current husband, ex-husband, writing in family. Nobody's interfering with her choices regarding her children. She ended up on top. Henry Tenon got $5,000. Mario Fernandez got the proceeds of a sale and got to remain in a marriage and go on a separate way. But the person who benefited in the end was one of the jury instructions we told jurors to look at. What benefit, favorable treatment, what do they get out of their testimony? It's the same motivation as to why this crime was committed. Who ended up with everything they wanted? Shanna Gardner, and that speaks to her being the one that put this whole thing into action. She has a pecuniary interest in this without Jared Brightigan having any legal entanglements her because he's deceased. She now can control her trust. There are years of incitement, and I anticipate and I understand. Maybe if there were some remote text messages that were joking from 2015, everybody jokes about their ex. I get that. Everybody in this courtroom gets it. There's nobody here who hasn't said something at some point in a joking manner, like these text messages about the insurance for the medicine or the little, I'm not going to say the word, referring to her son. But those people didn't end up dead. They didn't end up dead 10 minutes after leaving her house, less than a mile from leaving her house, shot at the hands of a person who's renting a home from her company that's funded by her.
What are you doing? What are you doing? She's making the point for the defense. What is wrong with her? Because the point that came out on cross with Mr. Baez was, look at the long list of people that they joke about killing or she jokes about killing, and they're all still alive. So therefore, when she jokes about killing, when it pertains to Jared, it doesn't mean anything. Like, in other words, if she says, oh, text messages and talking about killing people, if all these people also ended up dead, then you could make that connection and say that she means it. I don't understand what is happening right now, because why is she's making the exact point that the defense made. Look at all these people that she talked about killing and they didn't end up dead. What is happening?
Trust.
Boy, oh boy.
Implicating her current husband.
She's literally, I mean, the only other way you can say is like what she said there is almost all another thing you could say is that that's exactly why those text messages don't matter and shouldn't come in. But that was the evidence that you presented. Like, you wanted to get those messages in. Why did you want to get them? Like, okay, the only reason that the state would want those messages in and why they presented those with that witness, what's the point? They're trying to show it's evidence of premeditation. They're trying to show it's evidence that she was plotting since 2015. So you can't do that and then at the same time say those messages are all jokes. It doesn't make any sense. It doesn't make any sense.
No, there's no one unlucky or that naive in this world. But this woman didn't know about this, wanted to happen, and cover up everything that happened afterwards. She attempted to solicit other people. It wasn't just, I wish I could hire a hitman. It was, I'm not joking. I'm serious. Your Honor can read the text. Do you think M would do it? Do you think H would do it? There are days in a row where she's saying, should I talk to him? Should I reach out to him? Should I ask him? She tells the brother of the victim, I want to hire a hitman, and she's serious. She tells a tattoo artist because she probably, in her world, thinks a tattoo artist knows Hitman, if he knows anybody. Years and years and years and years go by, and defense counsel brought up a great point, which is this all stopped sometime in 2017. Well, that's when he meets Mario Fernandez Aldana, and he tells her, I've got a military background. By the way, I know 4 guys who can break into Jared's house, make it look like an accident, no one will ever know, or make it look like a burglary, no one will ever know.
Well,
There's no need to solicit a hitman she married.
I don't disagree with. Wait, hold on.
This all stopped sometime in 2017. Well, that's when he meets Mario Fernandez Aldana,
Correct.
and he tells her, I've got a military
Correct.
background. By the way, I know 4 guys who can break into Jared's house, make it look like an accident, no one will ever know, or make it look like a burglary, no one will ever know. There's no need to solicit a hitman she married.
Wait. Then who's Henry Tenon? I'm confused. Isn't he the hitman? I was going to say something else, but then I got distracted by that complete idiocracy. What was that? What was my other point? I don't even know. I'll have to back it up. That floors me. The number, dude, this is.
Thinks a tattoo artist knows Hitman, if he knows anybody.
Oh, I know what I was going to say. So I don't disagree with the idea that, again, if Shanna did this and if all these people did the things, I don't disagree with the idea that she replaced Kimmie with Mario, because that's exactly what I suggested yesterday. I was like, that's what that looks like. But again, what does that mean? That means that Kimmie is just as culpable. I mean, beyond, like, almost as culpable, right? Like she tried to find somebody through Sue, failed. Had she succeeded, Mario wouldn't be here. I'm telling you. Like, Mario became the new Kimmie because Kimmie couldn't find anybody. That was my idea yesterday, right? And she's literally saying that. So I don't disagree with that premise. But then the rest of it, that's the only thing she said so far that makes any sense to me. So
Years and years and years and years go by, and defense counsel brought up a great point, which is
again, her own premise is that I think has some potential to be accurate. All of that points to why is Kimmie not being charged then, right? And so everything that she says contradicts itself with, anyway.
stopped sometime in 2017. Well, that's when he meets Mario Fernandez Aldana, and he tells her, I've got a military background. By the way, I know 4 guys who can break into Jared's house.
Let me just play this out real quick, okay? She starts out with Mario and Shanna are lying in wait in the dark, and they pull the trigger. And my thought was, well, then how did Henry pull the trigger? Later on, she says Henry pulls the trigger. Okay. Then you've got she didn't need a hitman. She married one. Well, then who's Henry? Okay. And then you've got like I just pointed out with Kimmie, right? Like the text messages go all the way back to 2015, and because she look at how she was talking with Kimmie, blah blah blah. And then she swaps them out. I'm paraphrasing because this is what I've said, but what she's saying is that she didn't just try with Mario. She'd been trying this, right? So it implies like Mario came in and took that role over, right? That's what she's saying. Okay, well then how come you didn't charge Kimmie? So like that's just a couple things. There's even more contradictions than that. So
like an accident, no one will ever know, or make it look like a burglary, no one will ever know. There's no need to solicit a hitman she married. The money paid to Henry Tenon to complete this task is drawn from an LLC that she and Mario Fernandez jointly control that is funded by her trust fund. And the $5,000.
What her defense team could I'm sure will, and could very easily argue that the trust fund was in his name at the time, right? And that just because people are married, it doesn't mean they know it, or like, in other words, the trust fund was in his name at the time. Yes, they're married, and yes, the business is in their name, but remember, Henry Tenon also did legitimate work for them. So is it plausible? Is it plausible, right? Just to throw out the idea, right? If you're the defense, is it plausible or is it possible that Mario could have done this on his own? I'm not saying he did. I'm saying you could make this argument that Mario did this on his own and he was writing these checks to Henry, but that it wouldn't have raised any suspicion because Henry actually did work for them. And just because her name is on the account because they're married, that doesn't mean she knew what was going on. And she wouldn't have suspected anything because he was doing work for them. That's a plausible argument one could make.
Payment for the murder, he got $2,000, $3,000 for actual legitimate work. He was paid $5,000 for
there it is, legitimate work.
Business, which was
Legitimate work.
The first down payment on what would be a funneling of funds through him over time to repay him for this hit. And when Your Honor looks back at those wire calls,
that's the other saving grace that could come in even for Mario, I think, is the fact that there's a legitimate. I mentioned this yesterday. That's a big deal. Remember the fact that there's no text messages between the two of them, we learned that today. But then the fact that there's this legitimate work, that Henry was doing legitimate work, how the state's going to have to somehow prove that one check went to the murderer, not to the legitimate work, right? I don't know how they're going to do. It's going to have to be circumstantial, but I mean, that right there could be the thing. Because the jury, if the jury thinks to themselves, how can we know for sure what check was for what? That's an acquittal, in my opinion, because there's no way to prove that they hired him, or that one or both of them hired him, right?
Shanna Gardner is telling her PR firm and Kim Jensen that, oh, this guy Henry Tenon, they arrested for murder. There's one thing they could twist against me. It's that we gave him $5,000 last year. It is very telling to this court and should show her mind and her knowledge that she only mentioned that $5,000. She didn't mention the $2,000 and the $3,000. Those are for legitimate work. She knows the $5,000 is what they're going to twist because she knows that was the $5,000 earmarked for the hit. I'm going to anticipate there's no question that Mario Fernandez did this in conjunction with Henry Tenon. Henry Tenon gave a sworn statement saying as much. He's taken his plea of guilty to murder, second-degree murder. The children, there are some disputes about whether he was there or not there. Henry Tenon says he was there driving the truck. And Henry Tenon was on foot. Somebody was driving that truck. And Jacksonville Beach Police eliminated everybody else other than Mario Fernandez Saldana. By the way, Henry Tenon has said this after they've already found evidence of Mario Fernandez's involvement. Because it's corroborated. But Henry Tenon didn't know what evidence Jacksonville Beach Police had when he gave a statement. He pled.
I don't
on his
know.
first court date. There's going to be an argument that these are just words. The court shouldn't look at this as her responsibility, that she didn't assist Fernandez or had no part of this, had no knowledge of it. Her actions are strong indication of her guilt. It shows her as a conscious of guilt. It shows her as a willing participation in this. There was no renunciation of this. She sat in front of detectives with the Jacksonville Beach Police Department April 15th of 2022 and told them, I don't know what happened to Jared. Maybe it was a gang initiation. Maybe it
I
was.
don't know why they think that is such strong evidence. And look at her attitude, by the way. But like that blows my mind because like why they seem to be really relying on that, and I don't understand it because if you don't know what happened, you would try to think of things, right? I mean, I just don't understand. And even if somebody didn't do a crime, they're going to say, I don't know what happened. And then if somebody's like pressing them to come up with examples or suggestions, they're going to come up with things that don't make sense because they don't know. And at the same time, if somebody is guilty of something, they're hopefully going to say they don't know what happened. And then the same thing, same result. So same, right? But either way, it doesn't prove anything.
Was a drug deal gone bad? Maybe Kirsten Brady killed him. All while sitting there knowing that for the past 3.5 years, Mario Fernandez has been telling her every time they have a fight that he'll take care of Jared. That Mario Fernandez has been telling her that he would run him off the road, that he would follow him through his stairwell, that he was having a hard time taking care of it, meaning kill him, because COVID was preventing Jared from leaving the house. And then days before Jared's murder.
Well, okay, Miss Lady thing. Are you trying to suggest that it was Shanna didn't really want to kill him, but Mario just suggested it enough that she gave in? Remember those two conflicting statements about what happened after Hawaii, right? Are you trying to suggest that she didn't really want it, but like she couldn't stop Mario, that type of thing, right? Like going along with that idea that she would have to stop Mario. It was his idea. Are you trying to go with that? Or are you trying to go with Mario would never have done this if it wasn't for Shanna, which is what she said just a few minutes ago. You can't have both at the same time unless they're severed, unless these these defendants are severed. You're trying them jointly. You can't present both to the jury. Like, what the fuck?
Mario said during Hawaii, if you don't want me to do this now, you need to tell me.
When did that come out? I might have missed that. Who said that? Who would testify to that?
Ms. Jensen.
Oh.
Kim Jensen, these are all statements that Kim Jensen gave to law enforcement in the state of Florida
Oh,
in
wow, I know.
July of 2023.
Fucking hell.
And she testified to it, testified to Detective Johns on redirect at the grand jury in February 2023.
So that was her grand jury testimony?
Yes, ma'am.
For which part?
The Hawaii statement.
No.
The right
The Hawaii,
The what?
Hawaii statement.
The Hawaii statement.
That's what I'm going to term it, the Hawaii statement.
Okay, I'm sorry to interrupt.
You can hear them talking. She's trying to sneak a doodle stuff in and make it seem like it was said. I don't know. There was something fishy there.
She's being interviewed as a witness. She doesn't bring up any of this information, which is extremely germane and extremely of interest to investigators. And in fact, affirmatively sends them down a different path, bringing up these other theories. There's evidence that Ring camera footage that Gardner and Fernandez were provided the search warrant for Ring by Ring. I won't say inadvertently, but it should not have been done. And that there was footage that should have been there based on the habit of life of the recording device itself and what The investigators knew about the movements of the children that night and about other recordings that they were able to find. There was discussion between Ms. Gardner and Ms. Jensen regarding the ring. That discussion came days after Henry Tenon was arrested on unrelated charges. There's deletion of messages in her phone and in her cloud, messages that the detective testified were present in Kim Jensen's phone and not present in Ms. Gardner's phone. And by the way, the messages provided by defense counsel about killing the insurance salesperson and her own children were not deleted because she didn't really mean them. She deleted the text message about killing Jared Bradigan because she really didn't mean that.
I don't know
She
how
had different phones. I know there's gonna be a ton of argument that she was advised to this by attorneys, that it's not her fault, none of this is consciousness of guilt, but she's calling this a burner phone. Her own children are telling detectives, are you looking for mommy's burner phone? She's talking to Kim Jensen on the wire.
I was thinking about that today, and I was thinking that she might have just called it that because it was a temporary phone while they law enforcement had her real phone, right? Imagine if law enforcement has a real phone, they're doing a Celebrate on it or whatever, they're downloading it, and you just need a temporary phone. I could see her calling it a burner phone because literally it's like a temporary phone, right? I could see her calling it that and then the kids echoing it. I was thinking about that today, actually.
About evading law enforcement interception of their communication.
Like in the sense that it's not your real phone. It's just like, it's like a I don't know. It may, I don't know what type of phone it was, but she might have been thinking about it as a disposable phone in that it's temporary. She's just using it for the time being till she gets her phone back.
And she's not talking about it in the context of, let's talk about some embarrassing, intimate things about my life. They're talking about it in the context of Henry Tenon, truck, payments, the PR firm. Those are the subject matters where they stop talking and say, maybe we shouldn't talk about this on the phone. Maybe we should try FaceTime. Maybe we should try something else. There's an innocent explanation for everything individually. That's the totality of circumstances that you look at. No innocent person would talk this way, act this way, do the things she did, not do the things she did.
It's not, you can't say that. You just can't, you cannot say that. You can't say that. There are plenty of guilty people who end up being found guilty at some point later on who fool everybody and vice versa. There's plenty of people who are completely innocent, who act weird, and then people think they did it. You just can't make blanket statements like this.
She did and not say the things that she didn't say. Her contact with Fernandez during his trip to Canada, I mean, that's what the children said, he's going camping in Canada, but there's no dispute from the detective that Mario Fernandez started driving up the East Coast, that he had no pre-planned, prepaid hotel rooms. They were able to see that he's showing up in places, calling and getting hotel rooms spur of the moment, buying toiletries.
Now, this whole Canada thing, I don't know why they keep talking about Canada. It sounds like there's no evidence that he was planning on going to Canada. It sounds like he went only as far as Pennsylvania. But anyway, I guess they are talking about this to try to show why he shouldn't get bond. But I don't understand that either because apparently he's not trying to. I don't know.
And then when he's speaking to Shanna Gardner as her children are being interviewed by CPT, and when they leave, and she's able to have an opportunity to be alone with them, she calls him, and all of a sudden he turns and comes back home.
I don't understand what they're suggesting with that, honestly.
Adds up to a consciousness of guilt that shows that she knew this was going to happen. She wanted it to happen. She encouraged it to happen. And she ended up pleased with the results because she got everything she wanted. She didn't tell anyone about this. She didn't get a call from Mario Fernandez on August 18, 2022 about Henry Tenon in a broken truck and call Jacksonville Beach Police and tell them, hey, there's this guy, he's got a truck, you should look at him. No, she called her PR firm, worried about what they were going to charge him with. She told Kim Jensen on a wiretap that she was worried what Tenon was going to tell investigators and what Tenon was going to tell the police about the payments and how he was going to throw them under the bus for what he did because they were involved. Detective John said that Kim Jensen admitted at a grand jury and on that meeting in July of 2023 that Shanna Gardner had disclosed to her she knew about a man named Henry. She had been him before. She knew he had a broke down truck like the one the police were looking for on Onions. And in The Wire, the first call she makes when she's confronted by media after the planned leak that a big break was coming or an arrest was coming, her first reaction is that of a guilty person, which is she tells Kim Jensen, I didn't want to know anything else about it. I turned from the reporter and ran away. I got in my car. I left. You're over here on the wire recording. It's in evidence. Should I give Mario, meaning Fernandez Saldana, a man that she is separated from and hasn't spoken to in months and has no plans to resume her relationship with, should I give Mario a heads up about this big break in the case? I could go to Marlow Rogers' house and use her phone so that they can't hear it, so that they can't find it. That's because
that
she
implicates
wanted to
Marlow. That implicates Marlow. Are you joking?
Arrested. We've been caught.
Oh boy.
Your Honor looks
They
at her
really
motivation.
believe what they're saying. How have they not also like again, now that implicates Marlow. Now my thought, I don't remember if I fully fleshed this out or I might have interrupted myself, but I think I did say something maybe about how I thought it was funny, the whole moving right next to Marlow thing, the neighbor. Now I get it with Washington and the health and all that, but being her like literal next door neighbor. And I almost thought is like, is Marlow her new Kimmie / Mario? You know, not that she needs to, I don't know, like that thing about being able to go use Marlow's phone. I don't know. Anyway, but again, everything that they're saying is almost like, well, you think these other people are involved, but you're not charging them.
The financial trail back to her years of incitement, her years of intent, the fact that she used code words when she's talking about this. If this was a joke, there's no need for code words and deletions. There's no need to use FaceTime to evade a wiretap. The evidence does establish proof evident presumption great that she was a principal to first-degree murder, conspiracy to commit capital murder, solicitation to commit capital murder, and child abuse. Because she knew BB would be in that car. She was in that car every week for date night. It's important for this court, under Arthur and under pretrial detention statute, to look at the legislative intent. Under Arthur, this court could deny bond to somebody accused of armed robbery or any other first-degree felony, even with no criminal record. Not only is this the highest crime that someone can be charged with, first-degree premeditated murder, she's been charged with first-degree premeditated capital murder. There's a death notice filed. This is not just a dangerous felony. This is not just a first-degree felony. This is not just premeditated murder. It's cold, calculated premeditated murder. It's contemporaneous violence. It's pecuniary gain. We've established through the testimony of Detective Johns not only proof evident presumption great and substantial probability of her guilt, but of the aggravators as well. That she knew Bexley Brightingham would be in that vehicle for contemporaneous violence, that pecuniary gain, she knew that Jared Brightingham were dead, she could control her own trust, that she could move where she wanted and have her freedom financially and with the children, and that this was cold, calculated, premeditated, because there are attempts by Mario Fernandez and Henry Tenon on prior occasions, and they've been talking about this for years. And the actual concrete plan between Tenon and Fernandez, they've been talking about for months. And the amount of money they promised Henry Tenon, $150,000, was going to come from her trust. There was no way Mario Fernandez could promise that money without her blessing, because he had to get it from somewhere. Under Florida Statute 907-041, we're talking about the evidence of danger to the community, flight risk, and integrity of the judicial process.
Right.
I know the defense has elicited testimony and will make argument that she was willing to turn herself in. Her attorney sent an email to the state of Florida saying, let me know, I'll turn her in. And she moved to Washington to be with a friend and live in a nice house. Just because they offered to turn her in doesn't mean that she can move all around the country secretly and then turn around and say, well, you knew where to find me the whole time. Law enforcement had to actively track and seek this woman to find her. It's not like her attorney is emailing us. She's nearby. She's in Tallahassee. She's in Savannah. If you're looking for her, she's not in Washington. She moved across the country to a house purchased for her by her parents through an LLC. That's a lot of steps for law enforcement to find her, to find where she's living. Again, this money, these resources, this wealth that this family has that she has access to can be funneled.
Yeah, but the thing is like I know what she's saying. She's trying to say that was so that they couldn't find her, but that's not it. Because this is the thing is everything in her life has been done that way because that's what her family does. Her family has the money in and out, like literally everything that she owns has been done the same way. So that you can't use that like that. In other words, that's the way the family does things with everybody. Like that's their thing. So that argument falls flat that it was like intentionally to be hidden.
Through all of these companies, LLCs, shell companies, it would be impossible
Shell
to track
companies?
somebody with this
Shell companies?
many resources in this many ways.
Shell companies? See, now she's doing that thing again where it's like, are you implicating that the family is committing like, I don't know, financial crimes or something? She's implicated a lot of the way she's been talking about a lot of people. I'm like, it sounds like you're going to be charging RICO or something. Like, what is going on?
Ways to move money. They were going to move the money
Not charged if you
to
believe
Henry
it.
Tenon through a shell company, through a power business. They're going to seed this business, and that's how they're going to make these payments and launder this money through for this head.
Money laundering.
Integrity of the
Okay, money laundering.
judicial process.
Notice they're not charged with that though, right? Do you believe what you're saying, lady? They're not charged with this.
That's in the statute. It outlines
Right? I know.
this defendant has access, influence, and power over key witnesses and key evidence in this case. There's already been testimony that she has deleted evidence, that she is calling.
I mean, and you know what they didn't do? Marlow, they had every chance to go to talk to question Marlow about the family business because they got into the meetings and whatnot. They didn't ask her a question about this.
And Jensen, when she's on her way to grand jury, when she's on her way to the state attorney's office, that she's having her attorney call her. Her children are witnesses in this case. She has access now to her children in a way that can be monitored, but she would have access to her children and over whatever they say, don't say, know and don't know about the testimony they're going to give.
Oh boy.
She got burner phones. Her parents are witnesses. Her family
One-
members are witnesses.
Listen to this bullshit. There was one phone, and the burner came from the kid. And again, I as I thought about that today, as I explained, I think there could have been a reason why she called it a burner phone, why Shanna might have called it that, and then the kid picked that up. But I love how it's now the phones are multiplying. The phones are having baby phones. It was one, now there's multiples.
The state has serious concerns, and this court should share them about the integrity of this case and the judicial process going
I don't
forward.
like that at all.
Lastly, again, this is the most serious criminal offense there is, capital murder.
Also, just saying, burner phones doesn't necessarily mean you're a criminal. Really. I mean, it doesn't, unless you've done something criminal with them and they can connect that. It just doesn't, I understand it can look that way, but it's not enough.
Her
Yeah.
evidence shows she's been plotting this over the years. She exercised or showed a cold disregard for the safety of BB. The sheer depth and breadth and relentlessness of this plot, what she was willing to do and try to get other people to do and got other people to do, shows that she is dangerous per se by the resulting action,
Per se.
the resulting consequence of her action.
She's dangerous per se.
Whatever explanation for every individual action or every individual statement or every individual text over years and years and years and years that can be argued, there is no escaping that she set this event in motion, that without her, none of this would have happened. She may not have pulled the trigger, but she has Jared Brighting's blood on her
I feel like
hands
she's set a lot of traps for
We're asking
herself.
the court to grant the state's motion.
A lot.
to bail.
All right, thank you. I just want to clarify one thing, Stifler.
Just
When
one?
I look back,
Just one?
um,
Just one thing?
when I look back at my notes, what I wrote is that her family has an annual trip to Hawaii, and approximately a week before the murder,
Yep.
that Ms. Gardner and Mr. Fernandez went on the trip.
Uh-huh.
They returned 4 days before the murder. And then I have KJ text something about Fernandez, that Ms. Gardner was frustrated with Fernandez, and Fernandez was going to kill to save the marriage. Is that what you're saying was in the grand jury, or is that a text message?
I believe that Detective Johns testified as to many statements Kim Jensen made orally
She doesn't know. Or she's going to lie. She's not answering that question.
in a grand jury. Those were not in a text. The statement that Kim Jensen testified to at grand jury, and again reiterated to law enforcement officers
Oh,
in
boy.
July
Oh, boy.
2023, was that Mario told her in Hawaii.
It's not in a text. That's what she's asking. Judge Kite wanted to know, was that in a text message or was that not in a text message?
If you don't want me to do this, meaning take care of, kill Jared Brighting, you need to let me know now.
The thing is this. The way that this whole thing went down with Kimmie and the way that they had that thing with the interrogation and the messages, either they were threatening her in a way that's probably like illegal, or they were okay, let me put it this way. Either that's like the type of like that level, right? It's like either you're going to charge them with something or you're trying to threaten them to be fearful enough to be willing to say anything that you want them to say. I mean, like really that's what it looks like, because it doesn't make sense. It just doesn't make sense that you're not charging that person. So like that seems like that's something that's not allowed here, right? That seems like threatening someone with force in a way almost, right? Like threatening them, like, and the thing is, right, think about with Henry, at least that contract between him and the government is public information. But in that contract, it says, if he testifies truthfully, then he gets that deal. That's what it literally says. I've covered that already. And you know what that means, right? Truthfully, in the state's mind, they're going to be the judges of that. Now with Kimmie, we don't even have that. We don't even have anything in writing. There's nothing. So the thing is that because that interrogation was not recorded, and it's just, they're like, here's her statements, right? And at that point, I can't imagine it. Like at that point, they've got her, like they've done something, right? But that whole thing is not recorded. There's no, it makes this very, and so that's why Judge Kite is asking this question, because this is shady.
And that was days before he was murdered, and that was a statement she did not disclose to police at her interview.
And she got that information from who?
From Ms. Gardner. Everything Ms. Jensen testified to at grand jury, told to law enforcement, were disclosures made to her by Shanna Gardner.
There was no text.
Not like that, no ma'am.
Yes, ma'am.
The
Good girl.
statement about
She's
Mario
yeah.
Fernandez saying that he needed to save his marriage and do
You
this
see
to
why
save his
she's
marriage.
asking that? Because she's not stupid. She is seeing what I'm seeing, which is this bit with Kimmie, something's off here. And this, if you've got it in a text, fine. At least there's that. But anything that's just a production of that day that you interrogated her and after, I think is very subject to question. And anything that it's like, oh, this is what Kimmie says, Shanna says, well, if this is coming from her after that day and it's not, and there's no text messages from prior to that day, you see what I mean? Because prior to that day, the text messages from Kimmie are not at all what we're hearing now. You see what I mean? There's a change. It sounds almost like, I mean, I'm not trying to say anybody bribed her, but it's almost like they either threatened her children, or there's a complete switch, right? And Judge, that's why she's asking that question, because if it's a text message, that's one thing, but anything else is questionable after that day. Starting on that day and after.
That was an oral statement testified to by Detective Johns from Henry Tenon's sworn statement. Henry Tenon said, Mario Fernandez came to me and said, this needs to happen now, I need to see
I do have that note earlier, but I thought the Hawaii trip, there was no text message.
No text message. That was from grand jury testimony and then her oral statements to law enforcement in July of 2023.
All right, thank you. And I'll let the defense comment on that if you see things differently.
Yes, sir. Can I have a brief sidebar?
Yes.
I think it's very difficult. What's going on? What's going on?
Persuasion here. Evidence.
All right, Mr. Brady.
Yes, Judge. The state told you that this was a circumstantial evidence case, and we agree. The only difference is that we believe the evidence they have is both stale and weak. I want to remind the court that Article 1, Section 14 of the Florida Constitution says that the standard for an Arthur hearing is proof of guilt is evidence or the presumption is great. And if the state does not carry that burden, the defendant shall be entitled to release on reasonable conditions.
Okay.
If no conditions of release can reasonably protect the community from risk of physical harm to
So
persons.
here he's outlining how the burden is really on the state to prove. And if they do, then they get an Arthur hearing.
Assure the presence of the accused at trial, or assure the integrity of the judicial process, then the accused may, it's not a shall, it's a may, be detained. The state burden of persuasion here, proof evident or presumption great, is higher than proof beyond a reasonable doubt for the state to obtain a conviction at trial. That's Thornton versus Junior, 338 Southern 3rd 207. That's a Florida Supreme Court 2022. And to quote the United States Supreme Court judge, no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of her person, free from all restraint or interference of others, unless by clear and unquestionable authority of the law. And that is Union Pacific Railroad response for 141 U.S. 250, 1891. And that is routinely cited by Florida appellate courts that are reviewing habeas petitions on bond. Judge, I also want to direct your attention to Rule 3.132, the pretrial detention statute. And that statute says, a final order of pretrial detention shall not be based exclusively on hearsay evidence. Now you say that everything that Ms. Stifler just argued.
Yeah. I didn't know about that one. Yeah, she's screwed. It was all hearsay.
To get over the standard is hearsay. And to be honest, Detective Johns was not credible, and you can't even believe his hearsay. They didn't bring you firsthand evidence, and they could have. They could have called Kim Jensen to the stand for you.
Good point. They didn't.
They could have admitted Kim Jensen's grand jury testimony.
Ooh.
They chose to call a detective who couldn't even get his facts right. You heard.
Oh, you know what? So I remember seeing some filings. I don't remember where they are on the calendar or the docket, but I remember seeing filings where they both Shanna and Mario were asking for the grand jury testimony. And I think that it's like, that's all it says is like they're asking for, right? But I didn't know what that meant. Like now I know why they're asking for the, so in other words, because like he just said, it sounds like they're not providing the grand jury testimony, and that's the Kim Jensen alleged, from what the state is saying, right? Take our word for it. So that's, I guarantee you why they're asking for that grand jury testimony is for the transcript of Kim Jensen.
That he told this court that Mr. Byrd interpreted that comment.
Yeah, no, you're right. Just like yesterday, and just like all the other days, the state cited no case law. Thank you for reminding me. I was so distracted by all her just logical fallacies, and internal contradictions, that I didn't even notice it. I noticed it with Mr. Mizrahi though, and then Mr. Sullivan commented on it. Yeah, they don't ever use case law. Sorry.
by Miss Gardner back that she made in 2016 or 2015, whatever it was, that meant murder. Well, Mr. Bias showed him the report where Mr. Berg told the detectives. I didn't take it to mean anything at the time. He told the court that there was no way that Miss Gardner would have known about the blue truck in January when she made that controlled call to the courthouse, or even in August when she called her PR team. Within an hour after Mr. Tenon is arrested, detectives are at the house on Potomac Avenue that
That's
Mr.
why that
Fernandez owns,
yeah.
and they're telling the tenant there, Mr. Ordway, hey, your buddy Tenon's blue truck was used in the murder of Bradigan. And that wasn't the first time they were at that house. The detective told you that. And the detective also told you during cross-examination that after that, Mr. Ordway called Mr. Fernandez right away. And that sets up the link that Miss Gardner now has all this information because the state told you that they live together and they talk. So that is not that Miss Gardner had this information back in April when she spoke to the police. It's not that she had it back in March when she spoke to the police and she just withheld it. But if you're Miss Gardner and you have a PR team and you have a lawyer by August of 2022, what do? You reach out to them and listen to the wires because that's indicative of the conversation she has with these people. They never tell her to go to the police. So you can't penalize her, and it doesn't move the needle at all that she's guilty because she follows the advice of professionals. The statements of Kim Jensen that you heard 100% hearsay other than those text messages. And those text messages are old, and I'll talk about those. The testimony about Liam Bradigan. You saw the video, you'll have it, an hour and 23. I didn't play it, but he repeats himself at an hour and 34 minutes again. Yes, I saw Mario Fernandez in the house. He was playing video games.
Yeah.
An hour 23, an hour 34. And Your Honor knows that that is a child protection team interview, that those are trained interviewers. Their purpose there is to ensure that the child is not being coached and that the child is not being manipulated.
Yeah.
You heard the state say, well, the child was coached. She coached her kids. There's no evidence of coaching.
Well, and that's evident by the fact that the little boy clearly misunderstood the point of the question because he didn't understand that what they're looking for is the whereabouts, because the way they asked it is like, what was he doing? You know, and then he's like, oh, I think he was playing video games, right? Not understanding that they're trying to establish whether or not there was an alibi.
You heard a lot of evidence of suspicion and a lot about motive. You can read 1,000 cases, Your Honor, that all say that motive is not an element to the crime of first-degree murder.
Mm-hmm.
Let's talk about the text messages. These texts are in 2015 and 2016 predominantly, maybe some in 2017. The detective's like, oh yeah, this continued up to 2021 and 2022. Are you kidding me? Are you kidding me? Don't you think that the state, who has the burden here that's higher than beyond a reasonable doubt, would have hit print? They don't exist, Your Honor. They don't exist. What they show is they show dislike towards Mr. Bradigan. You have a friend venting to another friend over a very difficult co-parenting situation and a contentious divorce. And many adults in similar circumstances say the exact same thing. They're indicators of frustration, but not proof of a murder on February 16th of 2022. In retrospect, those words were clearly poor judgment, but poor judgment does not in any way equate to actual intent and does not prove misconduct in this case, which would be a first-degree murder. There is zero, and I'll talk about this, there is zero evidence that was brought before you today of any act by Miss Gardner that was done with the intent to carry out a plan or directly carry out the murder of Jared Bradigan. Detective Johns testified on direct, oh, it was contentious divorce. They were in and out of court. They talked about child custody. He hadn't even read the court filings. He hadn't even read the court filings. He told you that after on cross-examination when Mr. Bias brought it up. And what did Mr. Bias tease out? Mr. Bias brought up that it was about money. It was about money for Jared Bradigan. And what did Jared Bradigan get from Miss Gardner? Because money is important in this case, according to the state.
Right.
Jared Bryan stopped paying child support so the
It's a good point because because one of their aggravators for the death penalty is the pecuniary gain. They asked for it, right, to bring in the stuff about the money, even though both families were wealthy.
kids could go to because Miss Gardner wanted the kids to go to Discovery School. He fought tooth and nail.
Right. Correct.
And then Miss Gardner said, I'll waive the child support. Why? Because in reality,
And
she
the reason
did
is because there's no way to actually 100% prove motive, right? Right. Remember, the reason that they don't have to prove motive is because remember, the burden is like beyond a reasonable doubt. Motive is somebody's brain. You can offer theories of motive, right? You can offer. You don't have to, but you can. But the thing is there's no way to know for sure because it's like you can't be a mind reader, right? Like you can never know for sure. Even if someone confesses to a motive, I mean, I guess that would be the only way, but even still, right? You just, I think confessions are unreliable. So, but yeah, but if someone were to confess and say, I did it because of this, then they wouldn't be trying to prove anything, right? You know what I mean? They only do that when there's not a good reason. And it, again, it's like they don't have to, but they often try to because juries want it usually, you know what I mean? Depending on the case, right?
need it. And this is not an order so that she can be trustee of her own trust. You heard that Mr. Fernandez was the one writing the checks to the Discovery School. He was transferring the money. He was doing everything with the finances. It didn't matter to Miss Gardner. She had all the money in the world. All she had to do was ask Mr. Fernandez, the trustee. And Your Honor heard the reason for that. So that income, that money would not be directly attributable to Shanna Gardner so that then Jared Bridegan couldn't go after her for child support and say, well, she has all this money. But that's not a motive because there's no evidence that Shanna Gardner financially benefited whatsoever from the death of Jared Bridegan. There's this fallacy that Shanna Gardner, was free to do whatever she wanted. I think that's what Ms. Stifler said, that she could move to Washington. That is a false narrative, Judge. You heard from Megan White that Shanna was run out of town and cried when she left Florida. You heard from Marlow Rogers specifically about how it came about to where Shanna Gardner moved to Washington State. You heard that she lost her business as a result of the social media smear campaign. You heard that her children felt threatened, that she felt threatened. And that is all corroborated. Why? Because, Your Honor, you have it as a defense exhibit that the Gardner family spent millions of dollars on a home in Jacksonville Beach, and that home was bought, I think, 2 weeks after. I think they closed 2 weeks after Jared Bridegan was killed. Why? So the Gardners had a place as a family to stay when they could come visit Florida. And that type of investment shows that Miss Gardner never intended to leave Florida. And it shows that Jared Bridegan was never killed so that Miss Gardner could have this miraculous freedom. There's the fallacy of the baptism, right? That Shanna killed Jared Bridegan over religion. Well, first of all, you heard that in the consent final judgment that she agreed that the kids were going to be raised in one church. You heard that Shanna.
I definitely think there's more to this Mormon thing because they keep bringing it up, but like it's not fully fleshed out. But you know how it goes with this stuff. It's going to be a wormhole. Like if they really want to get into this, they're going to have to get into this, and it's going to be like a whole thing in and of itself. But that could have a bigger role than we realize. But they're going to have to go digging through all that. And I mean, it might be that they don't have time for all that, like either side, regardless of what the information is, because, you guys have seen how that plays out in other cases where it's just like this whole thing, you start peeling away the layers of the onion and you're like, where the fuck am I anymore?
They've been upset at first that the child wanted to be baptized in the church, but she did not obstruct it. In fact, she facilitated it. You heard that from Bishop Curry, and you heard that it was a coordinated effort. And the reality is, and you heard this from many witnesses, that Miss Gardner was not anti-church. She's still associated with them. Her family was still members of the church. She was not anti her daughter being baptized. That is not a motive. That is not a reason in this case. It's a false narrative. There's this idea that Miss Gardner was going to pay for Mr. Tenon, right? And how could she have not been aware of this $5,000? Mr. Fernandez was the trustee. He handled all finances. The trust is clear that Miss Gardner played no role in the finances. The bank records that you were given are clear, and the detective said it, that Mr. Fernandez wrote all the checks on that account that was used to write the checks to Henry Tenon. Miss Gardner played no role in that account or that business, though her name is on the LLC. Those homes were Mr. Fernandez's homes before they got married. Those checks that they admitted, those are all written by Mr. Fernandez. There is no financial evidence linking Miss Gardner to anything that has to do with this case. Mr. Fernandez even wrote the checks, Detective Reed, for the kids' school. I mean, the one thing that you think Miss Gardner, if she was gonna write checks for, would be the kids' school. She didn't do that. There is no physical evidence, no video evidence, nothing linking Miss Gardner to the killing. In fact, I think everyone agrees that she's at Walmart up until minutes before the kids get home that night on February 16th before date night. And the detective stubbornly agreed, but anything could have happened on that way home from Walmart. A crash could have occurred, traffic, and Miss Gardner wouldn't have been there for the kids to be dropped off.
I want to know
Why?
what she was buying at Walmart.
Would Miss Gardner cut it so close, Your Honor? Well, because she believed Mr. Fernandez would be there, which is what Liam Bridigan says in the CPT hearing. Henry Tenon, and this was clear, Your Honor, does not mention Shanna Gardner in the planning or execution of the killing. He does not ever even say he has ever met her, because Mr. Bias cross-examined the detective on that, and the detective corrected him and said, no, Tenon didn't say that. Miss Gardner says that in a phone call that she met him once 5 years earlier. And you'll hear that. And what is the state's theory of the killing? The state's theory of the killing is that Miss Gardner said, hey, I'm going to divorce you unless you go kill Jared Bridigan, and then I'm going to stay with you, and that's going to save our marriage. That's the state's theory. That's what Henry Tenon says. They had already told the school that they were divorcing. And guess what? They all but divorced. And because they did what they said they were going to do, the state somehow tells you that's evidence of first-degree murder.
Can I ask you about that? So
Yeah.
I want your view
Okay.
on that same statement that I just asked Ms. Stifler about.
The Hawaii statement?
Correct.
Well, what Ms. Stifler left out, I think the detective said it, was Shanna Gardner's response, according to Ms. Jensen, was absolutely not.
Okay. And that came not through a text message. That came not through a text message, but grand jury testimony. Is that your understanding?
That's my understanding. But I believe the detective said this because I think Ms. Stifler brought it out on direct, that Ms. Jensen's testimony was that Ms. Gardner said absolutely not. I don't want that.
And
And
this was delivered when she got back from Hawaii. This
it
was from Ms. Gardner supposedly
to Ms.
to
Jensen
KJ after the Hawaii trip.
after the Hawaii trip or during, or maybe it was a phone call from Hawaii.
Okay.
And so even if you believe Ms. Jensen, and Judge, I want to harp on this, right? The state didn't bring Ms. Jensen in here, okay? And that's an issue for them because we believe that there are credibility issues with that statement. But it's hard to get it when you're talking about double hearsay because Detective Johns wasn't even at the grand jury. And so that goes against the state that they didn't bring Ms. Jensen in here. If they're saying she's essentially the link to all of this, and you have hearsay. And at best,
Well, hearsay is admissible,
I don't
but it can't all be based on hearsay.
I don't disagree with you, Judge, but the problem that this court should have with that is that the connections here, they're trying to connect several dots, that the weight the court should give to the testimony of Detective Johns should not be given significant weight, especially with respect to Ms. Jensen. Because here's the problem with Ms. Jensen, is she wasn't brought in here. And then what are probably the most incriminating testimony from Ms. Jensen is not in the grand jury. It's when they pull her over and basically arrest her and transport her to the state attorney's office and then try and freeze her out by leaving her isolated in a room, making her think she herself is a murderer. And then she apparently makes these statements that incriminate my client, Ms. Gardner, but despite technology in 2023, no one decides to take a recorded statement for her. They don't say right after that, Your Honor, we're going to take a sworn. They don't write a report on it. And the first time that anyone on this side of the room hears about these statements is during this hearing. Because he told you there's no report, it's not even in my case file.
And
He said that.
I think that.
He said there's no report, it's not in the file.
Okay.
The state talked to you about this trip by Mario up north. Again, the problem with that is that how in the world would Miss Gardner know exactly what the children told the CPT interviewer? The reality is she didn't. There's this idea that she can hide behind LLCs and other things. Judge, look at the beach house property that I gave you. That was bought with an LLC. That's what her parents do. They buy homes in LLCs. That is not some effort to disguise Shanna Gardner. That's how they operate. And that's how they bought that beach house in Jacksonville, Florida in March 2022, when Detective Johns told you that Shanna Gardner wasn't even considered a suspect at the time. So this idea that she can hide behind LLCs and that's a concerted effort, again, that's another fallacy. This idea that Miss Gardner came up with these other theories about the killing, the timeline's important because that's early on in the case. She doesn't know anything. And does that change after Henry Tenon is arrested, after Henry Tenon's roommate, Mr. Ordway, is told that the blue truck is involved in the murder, after Ordway tells Fernandez, after Fernandez may have had a conversation with Gardner? Yeah, her knowledge admittedly changes. Okay, we don't dispute that. At best, she relied on the professional advice of others. I mean, at worst, Your Honor. Your Honor, she's charged as a principal. The state agreed that she wasn't the actual person that killed Mr. Brodigan, but you have no evidence of any planning, plotting, participation whatsoever in what happened on Sanctuary Boulevard on February 16th of 2022. Zero evidence. There's no evidence that she acted as a principal, which is one who intentionally, right? It's not like, hey, I hate my ex, right? That doesn't get you there. Saying I wish he was dead doesn't get you there. Saying 6 years earlier that does anyone know a hitman? That doesn't get you there. It's someone who intentionally aids, abets, counsels, hires, or procures that offense to be committed. And you don't have any evidence that she ever intentionally did any of those things. Now, Ms. Stifler spent a lot of time saying, well, this is a first-degree murder case. She's charged with capital first-degree murder. The state's seeking the death penalty. That was their decision, right? As this court knows, that is a discretionary decision to both indict her and seek the death penalty, and she is indicted as a principal. This very well could have been left in a conspiracy. That was a discretionary decision, and they act like, well, they don't tell you like, hey, we did this, and now we want, because we did this, you should do something. That's the truth. They didn't have to do that, Judge, and that is no reason for this court to consider in whether or not they have proven proof evident presumption great with regard to first-degree murder, because they haven't. Moving to the pretrial detention aspect, Your Honor, Ms. Gardner has no criminal history. Her entire family resides in the United States. She has never fled. She never fled Florida to Washington. In fact, she and her family made significant effort and expended significant resources and energy to make herself available to this court prior to her arrest. You heard from Mr. Coxe about the surrender, that he told the state she's willing to surrender. He told you that he had her come back here, so she was in striking distance. You have the email he sent. The state didn't take him up on that offer. That's their choice, okay? But at the end of the day, that's evidence of that she is not a flight risk. The law enforcement were out in Washington State in February 2023, executing a search warrant for the drones. They knew exactly where she was. And she has two young children that desperately need their mother, and one with a very serious medical condition that all but prevents her from fleeing, because he can only live in places that are below 1,000 feet sea level, above sea level. With regard to dangerousness to the community, no evidence whatsoever. You heard from Ms. Rogers about Ms. Gardner's conduct in the community while they lived in Washington, that she was well-liked, that she never observed any type of criminal behavior. Again, there's no allegation that she ever participated in the killing. She's charged as a principal. And this idea going back about burner phones and we're going to evade the wires, it's ironic, Judge, because they're talking about this on phones that they're saying are recorded, and they continue to talk about it. They're not evading anything, and the state didn't show you a single instance where they evaded any type of wire or law enforcement effort. The state goes after the word kill. Judge, again, those are old text messages, and she's upset and they're in the moment, just like she is in those other instances where she uses the word kill. So the state has not met their evidentiary burden of proof evident presumption great. They have not carried its burden to prove, and this is clear from 3.132, their burden of proof is beyond a reasonable doubt that Ms. Gardner would be a danger to the community if released. They've not proven that. And there are certainly conditions of release that can assure her presence at trial. I know that the state also mentioned the integrity of the judicial process and the family, but what did Ms. White tell you? She told you, like, hey, we were told not to discuss the case. We're not going to discuss the case. We haven't discussed the case. And she was pressed by Ms. Stifler like 10 different times. So the idea that because Shanna could have contact with her family, that would threaten the integrity of the judicial process, Judge, there's no evidence that supports that. None. In fact, you have evidence to the contrary. So going back to where we started, which is the Florida Constitution, that uses the term reasonable conditions. And that includes both monetary and non-monetary conditions. And we ask that the court not take into consideration the resources of the Gardner parents in setting that bond, because the reality is that Ms. Gardner herself is not a wealthy person. Any bond would likely be put up by the family, but the monetary amount—
I made that same point, right? That she doesn't have any money of her
should
own
not be
as
the
a
focus.
parent.
The focus should be non-monetary conditions, because this family has already demonstrated that they are going to spend money, time, and effort to make sure that their daughter is here before the court. We suggest that there are also non-monetary conditions such as a GPS device or other things that the court could consider, restrictions on travel, things of that nature, that could assure that Ms. Gardner understands that she must remain able and willing. I can tell you Ms. Gardner is willing to comply with whatever this court orders. And so, Your Honor, if Ms. Gardner is detained, it's got to be under the authority of the law. It has to be based on the evidence that happened in this courtroom today, and not on speculation, not on assumptions, not on unreliable hearsay. And Your Honor, we ask that you grant Ms. Gardner a bond with reasonable conditions.
All right, thank you. I'm going to take this matter under advisement.
Your Honor, can I make one more statement? It's a legal argument, it's not a factual one. Based on something the court asked defense attorneys.
Yes.
Okay, I just want to clarify the concept of whether hearsay alone is sufficient. And under State v. Arthur it is. I'm quoting State v. Arthur, and it says, because Arthur actually was about whether or not the indictment was enough in and of itself. Because here we have, this case has already been presented to a grand jury and they have indicted. The State v. Arthur says that the indictment is insufficient in and of itself. But the state's burden to foreclose bail as a matter of right is present when some further evidence, which viewed in the light most favorable to the state, would be legally sufficient to sustain a jury verdict of guilty. The state can probably carry this burden by presenting the evidence relied upon by the grand jury or the state attorney in charge of the crime. This evidence may be presented in the form of transcripts or affidavits, which could be totally hearsay. If after considering all the evidence, the court finds that the proof is evident and the presumption great, then as the defense attorney correctly stated, the court has the discretion to deny bail. So I just want to clarify.
All right, thank you for that clarification. I think I'm tired. So I think, no, so it's not enough for pretrial detention. It is for Arthur. My brain is barely functioning. Y'all have worn me out today. Okay, so I'm gonna take this matter under advisement. I thank everyone for your time and your patience tonight. I appreciate everyone pushing through, okay? And we have a court date on the 24th. So I will roll by order, and then we'll just come together on the 24th. We can just keep that date, okay? All right, so the next court date will be May 24th. It's 9 a.m. And that's for the case management hearing, but I'm gonna rule by order, okay?
You're at 1 p.m. or 9 a.m.?
I'm sorry. Yes, 1 p.m. Thank you.
Okay, so let's jump to that. Do, 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 do. Okay. Just see where we start here. No sound on the court.
It's not. Oh, it is. Okay.
All right. Mario's there.
Who's that driver? What is that? Okay. All right. Good afternoon, everyone. I apologize for the delay. If the attorneys could please place their appearances on the record.
Your Honor, Christina Stifler, Alan Mizrahi, and Steve Siegel for the state.
All right, thank you.
Good afternoon, Judge. My name is Jesse Dreiser, and I'm here with Shannon Day, my client, Mr. Fernandez, and Frank Tassoni.
All right, thank you.
Good morning, Your Honor. Patrick Carodi and Rosemary Peoples from the Baez Law Firm on behalf of Ms. Shanna Gardner.
All right, thank you. Good afternoon to everyone. And again, I apologize for the delay. We're here for a case management hearing. And I appreciate, did all sides get at least on Mr. Fernandez's case, the discovery issue memo? Okay. Is there anything similar for Ms. Gardner?
Judge, that was done with input from our side as well.
Oh, it was, okay.
Yes, Judge.
All right, thank you for that. So where I was left, I need to, or I want to gauge where the parties are in the discovery process. And my understanding, there's only been the deposition of those 2 witnesses that were related to the disqualification motion. Is that right?
Yes, Your Honor.
Yes?
Yes.
Okay. How many total witnesses does the state have?
Ooh. I don't have my. I know we're numbering close to 100. Obviously, we're not intending on calling all of this for trial, but they are listed as category A because they have some type of information. I did speak with both sides before Your Honor came out. I received the discovery list from Mr. Dreiser with input from Mr. Baez and Mr. Carodi, and we have formulated somewhat of a plan if the court would like to hear what we've come up with.
Sure.
Many of the items on this list, either there were no responses to subpoenas, meaning no records existed. We've provided some of these things, and I think owing to technical difficulties, which has been an ongoing issue with the volume of discovery and the types of files, some of this has been provided, but just did not transfer over. I'm going to re-provide the items on this list that I do have and are available. Next week, I'm going to go to Jacksonville Beach Police Department with my lead detective, lead ATF analyst, and paralegal and make sure that defense gets what they're missing. We've had some discussions about relisting some things to be more clear and re-providing the discovery in its entirety once they've gotten everything so that everybody has a copy of the exact same hard drive so we know what has been provided, what has not. So there's a record of when and what the state has provided. I think we're going to begin by working on that, and we have discussed looking to set depositions in the next month or so. I'll let Mr. Dreiser speak, clarify anything or correct anything.
I think our records show 86 category A's, 27
Okay,
category
thank you.
B's.
There may have been some added since the time of the filing, so we're close to 90 to 95 witnesses.
Are there, from the defense perspective, and that's to Ms. Gardner and Mr. Fernandez, any of these items that are listed, either on the state's exhibit or what you're raising as missing, that you believe need a taint review?
We sent another email this morning.
I've been in court all morning.
I don't think we included you on this one.
Okay.
So category A witnesses, so those are witnesses that are crucial to establishing the case for the state, right? So they are material witnesses, law enforcement, things of that nature versus just like character witnesses or like family, victim's family, you know what I mean? Things like that. So these are witnesses that are establishing for the state their theory of the case and the elements of the charges.
And what we had said in the email was, I don't believe there are any identified privileged documents that we could think of, with two exceptions. One, any text messages that may be on devices that were intercepted, and they would all correspond with no exception to the phone numbers that we provided to the state attorney's office. I don't have two phones. Mr. Sony doesn't have two phones. Mr. Hill and Ms. Day, it would be those phone numbers. And there could be text messages out there. There are text messages out there, and I assume the state at some point in time, at some level, at some iCloud has them. Maybe I'm wrong. I don't know. Number two, the wire. There may be phone calls that were recorded. I assume they would have been minimized. I assume whoever was running the wire had experience in identifying legal calls and would have immediately minimized them. But so I'm not in any way accusing anybody. I don't even know that they exist. I'm thinking what could exist hypothetically. With those two hypothetical examples, I don't believe that there's anything else besides what we've spent the last 6 months talking about, which is all those emails and the documents and whatnot. So when you ask the initial question, what needs taint review, or what could, we know that all of those things that are a settled issue at this point are out there, right? We know that Ms. Butler had them at one point. We know Detective Johns had them. We know they're on jump. So I don't know how to fix that. I think if I was making a suggestion, the state should collect all hard drives, thumb drives, Nextpoint applications alike, and operate solely off of, I guess, Agent Nazario's last provided.
Can I stop you there for just a moment? What was the status of Agent Nazario's taint review? Did he go through all devices, all the emails and those things?
During the course of his work with the state, initially, obviously, he was provided all devices. So the Cellbrite returns we have for the devices went through the taint process. Ms. Gardner's iCloud return, as testified to and is litigating this hearing, went to Agent Nazario after it was determined that it hadn't gone through originally. And
He went through every single file on there, doing what you all had agreed, which is, in my mind, based on the case law and the law that I was reading, a heightened standard of just content blind. And he's provided those reports to you.
Yes, ma'am. We provided him with Google returns for Mr. Fernandez Aldana and Ms. Gardner as well in November October, November, when Mr. Dreiser sent the letter about the two documents. We also.
What about Ms. Gardner's information? Because my understanding from reading the deposition of Ms. Butler is that once she came across, I believe it was a text message. When she came across the text message, she stopped. Then everything was taken down from Nextpoint. Has Nextpoint been uploaded again?
So that was
Did you all just stop?
Nextpoint was not up and running at that point where she was looking through the return. The decision by the state and by Ms. Butler and law enforcement was everyone shut down, deleted what they had, and that return from Apple that was provided to Detective Johns was sent to Secret Service, and we received the redacted version back, and that's what we've been working off of. Nextpoint, when we got this defense motion, was disabled all access, and it has remained disabled since.
Is that what you all intend to use to share information between parties?
We are still determining what we want to do. I know Mr. Dreiser does not want us to use Nextpoint, even if.
Yeah.
The state can use whatever they like to organize their discovery and prepare for trial. The defense has a strong objection that we want nothing to do with Nextpoint. What we learned through this issue is that Nextpoint documents what we look at, when we look at it, when we download it, how long we're on there.
Shared to everyone?
They absolutely have access to that, and I don't believe that the state should ever be able to know what we're looking at, how long we're looking at it, what we find interesting, what we don't find interesting. So we're going to operate solely off of providing devices like this, a 10 terabyte to the state at any given point. They can put whatever they want on it. There's no reason for us to use it.
And the original idea behind defense access to Nextpoint was not for them to use it as a viewing platform, just to have almost a Dropbox available to them that they would just download what we gave them access to, much like the CIP, the portal, and then not use Nextpoint after they downloaded each application. So they don't have to use it. We are in agreement that we're going to make sure everybody has duplicate exact copies of the same hard drive going forward, and cross-reference that with the list provided by defense counsel today and with the state's discovery demand. And I'll file an amended demand now that this proceedings are not stayed and we've reinitiated discovery. There are some obviously supplementals I need to file.
And
Go ahead.
that, the list that I sent, I just want to be very clear. It wasn't, the only reason I included the court was I wasn't really sure what today was about. I was trying to create a productive sort of roadmap of what I thought today would maybe your inquiries. But the state and I have talked, it was not accusatory.
I wasn't taking it like that. I appreciated it because I think the state did do a very thorough job in listing out everything. If you all had, number one, my question, it sounds like since we have essentially been stayed in trying to resolve a very important issue, nothing discovery-wise has been going on. And so I needed to know, based on what I didn't learn through those motions, if the defense, if the state, because I think that I would like the state to put the court on notice if there is a need for a taint review, that we get that accomplished. So, and my thought would be, is that it would be an independent agency, not a federal agency. I believe that frustrates this entire process. They are not under the jurisdiction of this court. Their witnesses have lawyers. They don't answer certain questions. Unlike the federal government, Florida is a open discovery state, and for them not to answer certain questions on advice of counsel, I don't think would be productive in these cases. So I was willing to go through that analysis, enter an order, basically outlining how I see that it should be done. So you're telling me that the Google Drives, the iCloud, those have all been reviewed for taint purposes. So
Yes.
you all have redacted copies of all of that information.
Yes, Judge, the original unredacted copies are still in the property room at Jacksonville Beach Police Department. I know at least Dreiser Hill has gone and gotten the unredacted copies directly from Jack's Beach. I'm in agreement with what Mr. Dreiser is saying. I'm happy to take everyone on the state's team, including law enforcement, whatever we have. I'm fine to be extremely cautious and abundance of caution. I don't have anything unredacted, but I don't mind sort of replicating that process to ensure that there is no inadvertent possession of anything, taking all our jump drives we have currently, all our hard drives, wiping them.
I guess, I don't know how
Reloading
much
it.
of that has been sent via email or communication, not any, or
I'm sorry, you mean the evidence
Any-
or the instructions?
any of the potential information that may cause problems that the law enforcement or the state should not have access to. Has any of that been sent?
Other than what we talked about in the hearing, which is the law enforcement team, not the state, was on the email for the iCloud that Ms. Butler began analyzing and notified the state. Then they all deleted their whatever email or attachments they had. That was sent to Secret Service, and Secret Service has provided reports to Defense Counsel of everything they receive from us and everything that they've gone through the filter process to do. But and obviously the 2 documents which were in the emails that were the subject. But other than that, I don't believe anything else should be in the possession of the state that is not redacted at this point.
Okay.
But I don't, Mr. Carodi can
Judge,
stand in.
there, with respect to Ms. Gardner, and I think it was just an oversight, the initial list provided to the state did not include Ms. Gardner's family law lawyers or at least one estate plan lawyer. We know that those emails between them and some text messages did get through the taint process. Because of the way the taint process was done, it was not a content review, right? And so the content review probably would have caught those. So I don't know if a remedy to that would that we provide another list to the state and the state can then, go back and do another review and remove that information.
Okay. That would be a yes on mine. I think that should be done.
Yes, ma'am.
And I do not want Agent Nazario doing it. And
I understand that.
and the state can have another agency outside of and truly unconnected to these proceedings, and I can give you time to identify those people. They need to have, what I learned through the deposition, they need to have sufficient computer forensic knowledge. They are merely to identify and redact. the state also needs to provide an unconnected lawyer,
Mhm.
not from the federal government.
Yep.
It doesn't matter to me if it's, the person needs to be unconnected to this investigation, that if that taint agent has a question, there will be directed to ask the lawyer, not the state.
Just for clarification,
I'm going to write it in an order.
thank you, Your Honor. An attorney, not with the state attorney's office, with a different state attorney's office, a private attorney.
I'm going to think it through, but it needs to be someone who has legal knowledge, the ability to research the issue for the taint agent. I don't know how much information is this? Should it be plural agents?
So no. I mean, if you're doing the search the way they did it initially, us personally, we've probably found about 10 to 15 communications. So that's what we have found. I don't think it's a heavy lift. I think if they're going to do the same sort of content blind review that they did initially, and we give them the email addresses, we give them the phone numbers, I think one person could do it in a day.
Okay, so is that the agreement still, this content blind?
That we're going to defer to the state on that. I mean, if it,
I need to know.
right, and we would be okay with that. As as the court identified, that's a more stringent standard than reviewing it and determining the content and whether the privilege applies, which is a legal determination. If we are going to go with reviewing the content, it would be our preference that those exchanges be identified, and then there be a judge that's appointed to review those communications and determine whether or not we would object to someone that is employed by the state of Florida determining whether or not privilege applies.
And I don't think any of that's necessary. I'm in agreement with, we have no interest in reviewing the contents of her attorney-client privilege communications.
So
Whether they're privileged or not, we're not going to look at them. We'll do a content blind removal of anything.
is FDLE involved in this?
Mr. Mizrahi is suggesting FDLE.
Are they involved in it?
There is an FDLE report. The laboratory is, but not the investigative agency. And they
They have a computer forensic department, don't they?
yes, ma'am.
Would there be an objection to that? And FDLE has a built-in attorney that they could ask, and any question would not be resolved by that lawyer. The lawyer would be able to help identify and then bring to the court's attention through motion.
Yes, Judge, that's fine. As long as we're doing what the state is saying is we're just identifying email addresses and phone numbers and then striking the data. So
Well, if there's a question, I'm going to make that agent/lawyer duty bound to identify for the parties, putting all on notice, so we could have an in-camera review. That would be my thought, not that they resolve it amongst themselves.
yes, Judge, I think we would have no objection to that.
But I'm asking, is there an objection to FDLE?
No, Your Honor, with the agreement that FDLE then is conflicted out from any future participation or testing in this case.
Mhm.
They are,
They are the testing agency for the state. That's why
Yeah, FDLE is the Florida Department of Law Enforcement.
they have a separate computer forensic department.
that their forensics be conflicted out from any future work on the case,
Do y'all want to think that through before I put it in an order?
like the computer forensics. So we don't run into a situation where down the road, the same people that are identifying these privileged messages are then tasked with additional work related to this case.
Right.
That makes sense.
So as long as we're willing to conflict out that section or that group of people that are
Right, that group
assigned
of people. Yeah, that
to
makes
provide
sense.
on this from further
Yeah.
participation in this case, then
Yeah.
we're okay with it.
That's agreeable to the state.
And first I need you all to ensure that they have not done any work. I don't want you just,
The FDLE laboratory has done some work. I would have to look at the report. I believe it was ballistics on some shell casings. Our DNA work has been done by ATF lab. I know that.
all right. And what I want to know from the state is whether the Florida Department of Law Enforcement will be willing to do something like this before I put it in an order. If they are willing to do it, it makes sense if they don't have investigative involvement in this, because there is no necessary expense. They have a lawyer that person could go to if they did have a question.
Yes, Your Honor.
And then the question wouldn't necessarily have to be resolved. It would just be identified, and that lawyer could file a motion with the court so that everyone is on notice what the issue is.
Yes, Your Honor, we will reach out and contact them.
Were you going to say something, Mr. Crody?
When you say on notice what the issue is, you just mean a bare bones filing that an issue's been identified. I imagine the state would not be told.
Correct.
Okay. Yes, Judge.
Just like my thought would be the way that you all identified it for me, file A, file B, not the contents of the file, not anything being revealed, just that, let's say, list of file A through F are questionable, and put you all on notice, because it comes from the defense side. The way that I read the Sullivan case, which obviously wasn't reported, it is a federal case. I thought, even though the court was critical of the process, the court was involved in the process, and while not perfect, it does provide an extra layer of protection for the defense and the information that law enforcement is not provided. I don't know if we necessarily need it. If the agent or the forensic person is able just to identify by number. My concern, to me, it was enlightening, but Sullivan, it dealt with the iCloud and electronic information. What I was kind of looking for from the defense is if, with the amount of information, was there anything like what happened in Sullivan, where there were pictures of strategy boards, or if there was any thought about any of that? It didn't just come in the form of electronic information; it came in the form of like pictures on phones, and I don't know if y'all have gotten that far into things that you would want that level of review on those devices. The devices is where I would think it might be the Google return. It might be a phone number, an email address that won't give any protection to the defense.
We spent time anticipating that may be what we thought the court was going to ask. And we can't think of much more than what I identified earlier in the hearing. I mean, look, as all the case law has been coming out the last 5 or 6 years from the Supreme Court down, our phones have become such an integral part of our lives. I can't say, and it would be to our own peril, that I can't say that Mr. Fernandez and I didn't have a picture of something that I just can't remember or think of. But we have thought about it, and we cannot think of anything more than what we've identified.
Right.
Okay, then we'll operate from that. So I'm gonna, by the next court date, I need an answer of whether FDLE would be willing to do what I'm proposing. If it's not that agency, then
So based on
hopefully-
what's happening here, this is the first part of this, the status here, or case management. So they're still trying to figure out going forward how to deal with this attorney-client privilege and who is going to be responsible for being tasked with, again, like I've said before, like sorting things into 2 piles, right? Is it privileged or is it not? And then, take it from there. So they're trying to figure out who can do that without adding additional conflict.
well, you'll have some time to think it through. In my mind, it needs to be whatever. To me, it has to be an agency for the integrity of the evidence. It has to be some type of, or a company, I don't know, that can maintain the integrity of the evidence, not manipulate it. And that there will always be a clear version of what this was and then what is redacted and it comes out. That whatever agency, or I keep saying agency, but whatever company or agency that happens, they need to have legal counsel available for questions. That legal counsel's
Right. And the
duty is
reason
going to be
she's
to
saying that is because what happened already is you had the taint agent, quote unquote, coming to the prosecutor to ask, because he's not an attorney, right? He wasn't trained to ask questions. So what she's saying is they need legal counsel. So if any of these, whoever is tasked with this, if they have any questions, if they're unsure, they can ask the attorney, but this is completely separate, third party, no conflict.
the court.
But like, in other words, don't come to the prosecutor and ask.
They report to the court. I will resolve issues if necessary.
Yeah.
Just so I can give them an idea of the scope, we're including all the devices, all the Google returns, and the iCloud return.
And the wire.
I think the other thing too, just thinking about this, because of the fact that Judge Kite did not disqualify the prosecutor or the state attorney's office, but she did say certain information or certain data that was at issue would be suppressed. I think this is like giving them a second chance. By them, I mean the state. So she's trying to make it foolproof that they can't fuck it up. The flip side of that is if there's some other infraction going forward after all these things are put in place and they went around it in some way, I think it'll be a different story because she's giving them a second chance to do this correctly. She's trying to make sure they can't fuck it up.
I'll let the court
You know,
counsel know that.
she's trying to make sure they can't fuck it up so that therefore, if that does happen, there will be no doubt that it was willful, right?
I'm happy to send it to them because there won't be anything to redact. We did not record and minimize any conversations on the wire associated with attorney-client phone numbers. They were just not monitored at all, if that makes sense. They weren't pulled up and then minimized. We saw the number coming in and just did not pull it up, listen, and record it. But I'm happy to send the wire. That should be fairly quick.
Did you include numbers from the other attorneys that that are unrelated to the criminal case?
as her estate lawyer and her family lawyer. I don't think we had those numbers, obviously, at the time of the wire. We had the Bedell firm's phone numbers and Dreiser Hill's phone numbers.
You need to include those. So
Yep.
that might need to go through
Yep.
review. I'm not,
I know, I'm happy to do it. I just wanted to, just for information
Okay.
purposes.
what is the plan for the discovery depositions?
We have discussed while I'm re-providing some of the discovery, I think we're in basic agreement that we can begin depositions, at least relating to the homicide scene itself, because those witnesses likely don't have any information relevant to any of this supplemental investigation and discovery. So I know there's a lot of defense attorneys to coordinate their schedules. They're going to give me some deposition dates to begin scheduling those. And what we've planned on doing is scheduling 2 full days at a time so we can take a significant number of witnesses but we are working with so many attorneys with demanding schedules.
Do you have a time frame?
I'm deferring to defense counsel on this.
We want to get moving. I mean, we're not trying to delay it. So I'll send an email out this afternoon to all the defense
How
lawyers.
many attorneys are coordinating?
So I can't speak for the other office. My office is going to divide and conquer to the best of our ability. So it will not be a scenario where, with the exception of
That's funny.
a few very important and specific depositions where I have to be available, Shannon has to be available, James has to be available, Frank, I mean, we understand that there'll be times where we all need to make ourselves available to do this. I get the impression from my interactions with the other firm that they'll operate under a similar way of dealing.
Mr. Crody, you're on the hot seat.
Judge, we have the same position as Mr. Dresser. There are going to be some depots where I think we're going to have,
I know. What about these initial ones?
I think we can schedule those fairly quickly and divide and conquer.
I think we could probably aim for a June deposition date.
At least for a day, sure. I don't know if we'll get 2 back to back, but yeah.
Okay. When do you think you'll go through the list and update your discovery?
I'm planning to take the hard drive to Jacksonville Beach Police Department next week, so I'm hoping to have an update by end of next week or beginning of the following week.
Okay, I'm going to go forward a little bit because this is just they're getting into the schedule. Some of the other more important things they already discussed. Came up with a game plan.
30 days so that I can get an idea,
Providing discovery out there.
Guardian ad litem, children. Let's see what this is about the kids here.
Just to ensure that the children's rights are upheld. And maybe at some point we could agree on a person, but I just want to put down the court's radar that would be something we'd like to accomplish before the children's depositions are taken.
the state is going to take depositions of the children or the defense?
The defense.
I want to depose the children sooner rather than later because there's work more about that. So I brought it up.
Mhm.
Where I want to start. And then the state brought up the issue just before a moment ago. And I have sort of said, I don't want to talk in that one. But they have an attorney I like, already like, but in fairness to Mr. Crody and his team, they wrote this mother of children, they do it wrong, and that's why, so that's why Crody got set up. It was a my request, take them, and now they're, that's how it should be done.
Judge, we are not going to be a roadblock to Mr. Dreiser taking the children's deposition. I don't know what the state is trying to achieve by seeking a guardian ad litem like 2+ years later after the incident and after our client gave the state full access during the CPT interviews, which are recorded and near in time to the incident. So the idea that these children have rights that they need to be protected, I'm not sure what the state is talking about or what they're seeking to achieve. We are, and we'll fight that battle if we have to in the Washington courts, but we have no objection to Mr. Dreiser trying to depose the children. We will facilitate that. We will make them available. We will make sure that they are in a place that complies with Florida's rules regarding depositions for children. And so I don't know, and if the state files a pleading, we'll review it and respond accordingly. That's the best thing to tell the state now, or tell you now, Judge.
Well, I think to just start this whole process, schedule it, get it on your books. And if that's Ms. Gardner's position, then it gives everyone goals to get it accomplished. And then you can start working from that date. But just saying I want to do it and then not having a date, let's put it on the books, okay?
Okay, let's go for it a little bit.
The next court date, I'm not going to pass it off far
I'm gonna reach out initially this afternoon.
next week. So
The 31st?
that's first and then go in the next court. And I have also on the state's,
Bond?
well, on the defense motion, that is in Ms. Gardner's case, motion to set bond and the state's
Okay.
motion for pretrial detention.
Here we
I've ruled
go.
on that and I said I would do it by order, which I have copies for the parties. I've carefully considered the evidence that was presented during the last hearing, and I've granted the state's motion for pretrial detention and denied the defendant's motion to set bond. I'm filing that now. The original is on top, Mr. Hathaway. All right, thank you. Court's in recess.
Oh,
Yes.
that's it. So, okay. So I had that document. I think I deleted it though, because I was like, oh, if she's going to put it on the record, that's so funny. She didn't say anything about it. Hold on. Let me just see. Yeah, I deleted it. That's really funny. Again, I kind of mentioned this a minute ago, where I feel like the distinction here with Shanna potentially is the family's wealth. I think that's probably what it came down to. And I don't think that it's lost on the court, even if the court doesn't explicitly say so, that the thing about the family trip to Hawaii, as I've mentioned before, and the timeliness of that. And then you also had the state making allegations about the family with like money laundering and fraud and all this, and, shell corporations and whatnot. Those types of things, again, in a way, make it seem like maybe the family, I don't know, right? Again, there's not been anything brought against them, but, if the whole thing hinges on, is the family going to not support her by giving her money to flee? Can you believe that, But let me see if I can find that and pull that up, just in case there's anything else enlightening as it regards to this. Give me just a moment. Actually, what I can do is this. While I'm pulling that up, they have another status conference that the one they just talked about. That's like right after this. Let me see here. Hang on. So this is from May 31st. So yeah, so again, just right after. Let me pull this over here. Hold on. Okay, hold on just a second, guys. Okay. So we'll go ahead and play some of the status here, and it'll be quick, just while I'm finding this document.
Good morning. Good morning. Okay. We'll be just in a holding pattern until they come back, okay?
Well, let me go for it real quick. I guess there's Shanna. There's Mario. Okay.
I have one. Thank you.
Peoples for Ms. Gardner. I believe Mr. Bias is on Zoom.
Yes.
Mr. Baez is on Zoom.
All right, thank you. I don't think Zoom is up, but you, Mr. Baez, I can see him.
Get that up so we can see him.
All right. I really brought us all back together to hear from the state of Florida about, number one, whether there was any additional information that or evidence that needed to have a taint review. And then if FDLE would be willing to be the agency.
We were able to confirm with FDLE's cyber team, we have an agent in place who's willing to do the taint review. I think we've agreed with Defense Counsel on all the devices, the Google and iCloud cloud returns, the wire, although I don't believe there's any on there. And then we also are going to we have jail calls for both of the defendants from Washington State and Orange County. I haven't reviewed those yet, but I'm not sure as to whether how it is that they do an attorney line. So we're going to send those to the taint team as well.
And FDLE would be the agency willing to do that.
Yes, Your Honor, they did let me know that they're going to get the extraction that Secret Service has already done. They're not going to re-download the devices. And then we are going to have them go to both Jacksonville Beach Police Department's property room and to Secret Service to obtain all the evidence. All other copies that we have of what should be the unredacted forms of evidence, we're just going to delete our team and wait for the re-filtered returns from FDLE.
Do they have an attorney in mind?
They did have an attorney with FDLE. Mr. Mizrahi spoke with them.
They have attorneys in place with the department that they can ask, but since we're doing the style of taint review that we're doing, in all likelihood, not necessary.
I know, but I do want to identify that person.
I don't have an identity, or I can find the name of the person.
We have the name of the agent. We don't have a name of an attorney.
Who's the agent?
Christina Fernandez, Kristina.
Do you have a time frame?
They're willing to meet with us early next week, and I'll have a better idea from them how long this would take. But if we're doing the basically search and delete method, I can't imagine it would take more than a few weeks at most. I'm hopeful just a few days.
And that's what the parties have agreed on, content blind review.
Yes. I mean, from the state's perspective, yes, I believe that's the agreement.
Yes, Your Honor, and I provided a list of additional attorneys to the state this week, so that they should
I
have.
need you to give that to me. I'm that the parties have identified about the procedure that shall be used. If there's any questionable material, that it should be brought to the court's attention.
Okay, so let me pause that real quick. Okay, so let me pull this up. So since she didn't, because it's so funny because like with the last ruling she made, she did make a very thorough oral record of her decision and her findings. Let me unshare, reshare. And I was expecting her to do the same and she did not. So, okay, so here we go. So order granting state's motion for pretrial detention and denying defendant's motion to set bond. Standard for pretrial detention in a capital proceeding. The right to pretrial release for a defendant awaiting trial is enumerated in Article 1, Section 14, which states, unless charged with a capital offense or an offense punishable by life imprisonment and the proof of guilt is evident or the presumption is great, every person charged with a crime or violation of municipal or county ordinance shall be entitled to pretrial release on reasonable conditions. So the key thing here is unless charged with a capital offense or offense punishable by life imprisonment. So So in other words, this would say like if you're charged with like first degree, right, offense punishable by life imprisonment or it's a capital offense, then you're entitled to pretrial release on reasonable conditions. Okay, so that right there would say that she's not supposed to be released, right? Okay. The Florida Supreme Court has placed the burden on the state to prove a capital defendant's guilt is evident or the presumption is great, as discussed in Arthur. So this is what we heard a lot about that when they were arguing about the presumption. So that's where the argument from the defense came in that they didn't meet that standard because they didn't give a presumption that a jury could find the first degree murder, right? And why does that matter? Because if they say there's no presumption that could be found, that there's not enough evidence there, then guess what? That means, like looking at this again, right? Charged with a capital offense. What happened with Florida v. Arthur and why they have the thing called the Arthur hearing, right? Is because what they're saying is sometimes the state overcharges, as we all know. So in other words, the state can charge you with a capital offense and then therefore you shouldn't be given pretrial release. However, The exception to that is if, and again, to have the Arthur hearing is saying, hey, look, the presumption, right, that the jury could find this capital offense that they've been charged with. Is there a presumption that is reasonable, that a jury could find that? And if not, then even though they're charged with it, right, they should meet the conditions for reasonable conditions for pretrial release. So the state's burden in order to foreclose bail as a matter of right is to present some further evidence which, viewed in the light most favorable to the state, would be legally sufficient to sustain a jury verdict of guilty. The state can probably carry this burden by presenting the evidence relied upon by the grand jury or the state attorney in the charging crime. This evidence may be presented in the form of transcripts or affidavits. If after considering, so that would be why the state put on that detective as their witness. If after considering the defense responsive showing, the court finds that the proof is evident or the presumption great, then the court has the discretion to grant or deny bail. On this issue, the burden is on the accused to demonstrate that the release on bail is appropriate. So we kind of talked about that before too, about how each side kind of had their own burden, right? So initially the state had the burden to show that their evidence, right, is supporting the crime as charged, right? Viewed in the light most favorable to the state. And then the defense has the burden, as we saw, to then prove that, or to show that, to show that it's not enough, that it's lacking, right? Okay. This standard can often be misinterpreted as the court commenting on defendant's presumption of innocence. For clarification of the standard and the findings required, the court cites the concurring opinion of Justice Curiel. I write separately to address what the dissent calls the liberty interest protected by Article 1, Section 14 of the Florida Constitution. We have said that provision, quote, embodies the principle that the presumption of innocence abides in the accused for all purposes while awaiting trial. So we've just to quote like Justice Newman, right? Judge Newman, that you're cloaked in a presumption of innocence, right? All the way until you get a verdict, if it gets to trial. Though it may result in a denial of bail and in a real sense affect a liberty interest of the defendant, a judge's ruling at the conclusion of an Arthur hearing does not mean the defendant is presumed guilty, even if the court finds the state has met the proof evident presumption great standard. For an Arthur hearing, while it involves a proffer of what the evidence may be at trial, which is what we saw, right? A proffer of what the evidence may be at trial. That's why. It is not a trial at all. It is before a judge, not a jury. Its purpose is not to determine the defendant's guilt, but whether the defendant is eligible for bail. If so, on what conditions. For these reasons, the deprivation of liberty. So this gives us more context as to why this was not your normal bail hearing, right? Because really, I thought they were talking about having an Arthur hearing. I guess technically that was an Arthur hearing because that's what we saw, right? We got a little snippet of some of the things that we presented at trial. And that is specific to Florida. That's Florida case law for Arthur hearing. So not every state will have that. Now they might have their own version of it, right? But in Florida, it's an Arthur hearing. Okay, so factual findings. At the Arthur hearing, okay, interesting to see how this judge will have interpreted it. At the Arthur hearing, the state presented the testimony of Detective Christopher Johns. His testimony established that he's intimately familiar with the case. After considering the testimony of Detective Johns, observe his behavior, and compare his testimony to other evidence produced in the court or in the hearing, the court finds the following facts credible. So what will be interesting here is there's probably going to be things that aren't mentioned unless she also has a paragraph for things she found incredible. So keep this in mind, right? She's saying after considering his testimony, observing his behavior, which is, I find that interesting, observing his behavior. For example, when he made those funny faces, I pointed those out and I'm timestamping them, by the way, from the last hearing. And compare his testimony to other evidence introduced in the hearing. So in other words, there were a lot of things he said that were kind of found to be not so reliable. So that's noteworthy, right? This is interesting. This is really important. This is Judge Kite saying, here's what I found credible. It's not going to be everything he said, right? Defendant and Mr. Bridegan had an acrimonious divorce in 2015. While the divorce only took months to finalize, noting that, it was followed by years of litigation over various issues, such as child support and shared costs of medical equipment for their son. Well, there were disagreements over who could be around the children, blah, blah. The co-parenting relationship deteriorated. Because of this, they resorted to having separate childcare events. Yep, that all bore out. In response to the issues, defendant made comments to others about wanting Mr. Bridegan to be killed. Her conduct crossed from wishful thinking to conspiracy. Interesting that the judge found that. She asked her friend and confidant, well, here we go. Again, what does this point to, guys? And there's going to be a footnote, KJ. She asked her friend and confidant, KJ, if she knew anyone or knew someone who might know someone, or even if specific people would be willing to kill her husband. Again, I'm sure it's not lost on Judge Kite that KJ is not being charged. The full name of the witness was, it's just about the fact that they're using her initials. Okay, well, we know it's Kimmie Jensen. It's very clear. In 2018, defendant married Mario. According to KJ, defendant discussed Fernandez as a strong contender, someone to be. It almost seems like she married him because she thought that, maybe, in a way. I don't know, maybe. She bragged to others that Fernandez had previous military experience. Now, what's interesting is we don't know if that's true. So far, what's come out is just that she has said that. Shanna has said that. I don't know if that's true or not. We don't know at this juncture. And was both willing and capable of gathering a group of men to kill Mr. Bridegan. On numerous occasions, Fernandez offered to kill Mr. Bridegan, especially when the defendant was upset with Fernandez and he wanted to regain her favor. Defendant told KJ that Fernandez would watch Mr. Bridegan's movements and develop patterns. See, again, all that speaks to the fact that they had never met. The defendant's significant financial means were placed in a trust to shield funds from her ex-husband. Oh, wow. The successor. So this is actually, we didn't get this in the hearing. Okay. Here's what the language is on that document for the trust. Quote, when our daughter, Shanna, shall have no further legal entanglements with her husband, Jerry Bridegan, she may elect to serve as the trustee by delivering a signed and notarized document to the trustee then in the office. Fernandez was the trustee of the Shanna Gardner irrevocable trust account. Okay. Outside of her being listed as a co-owner of the business, defendant allegedly did not have any involvement in the family finances. Instead, Fernandez handled all transactions, including, remember, this is what I've mentioned before. All of this separates Shanna from the finances and points to Mario. And why does that matter? Because that's how Tenon was paid. Okay, this is what happened that night. Good Samaritans. The only consistent theme from many he interviewed was that the defendant hated Mr. Bridegan, hated having to share custody. Although the custody thing seemed to not really be what it was. Remember how I said it? People maybe confuse that with child support. Okay, pretrial detention Arthur analysis. Okay. First degree murder is only relevant to the charge, the only relevant charge to the Arthur analysis because it's the only charge that's a capital offense. There's no dispute that the defendant was not the person who physically pulled the trigger, nor was she at the scene. The state submits that the defendant was a principal of first degree murder pursuant to blah, blah. She's a principal and may be charged, convicted, and punished for the offense. Notably, the law does not require a principal to be present at the scene. It is evident that the defendant aided and abetted in the murder of her ex-husband. It began with a clear pattern of the defendant attempting to find people to be her hitman. She asked friends if they would be willing. She asked acquaintances if they knew anyone. They were not just tongue-in-cheek comments. It's interesting. This is what the judge is finding because the jury could find this to be different, right? They were not just tongue-in-cheek comments a person makes out of frustration, as the defendant argues. Interesting. They were overt actions occurring over multiple years. So basically, here's what I'm taking from this. The judge kind of believes, I think a lot of this hinges on, again, all these communications with Kimmie. These, before she met Mario, again, that's noteworthy, from 2015 to 2018, all these communications, the judge finds those to not just be tongue-in-cheek comments or jokes, right? She thinks that they were legitimate. When defendant was not explicitly asking if someone would kill her husband, she was lamenting to others how terrible he was. Once Fernandez was a larger presence in her life, the search for potential hitman ended, but the bragging about Fernandez as the person to eliminate her husband began. There is no evidence Fernandez had any issue with Mr. Bridegan outside of the defendant's issues with him. This is what I've been saying. And again, this really points to me to why is Mario not being charged as the middleman and not a principal? It is logical that the defendant was verbalizing her frustrations with her ex-husband to Fernandez. Moreover, as time went on, the defendant was convinced that Fernandez was the right person to facilitate the murder. Missed opportunities. Shortly before the murder, defendant and Fernandez were on a family vacation in Hawaii, and their relationship was not on the best terms. Fernandez told defendant that the murder of Mr. Bridegan was imminent. And if she didn't want him to follow through, she had to tell him. Now that came from, I believe that came from Kimmie. That was the thing that was not a text but verbal. Defendant left Fernandez with the impression that this act could save their marriage, therefore encouraging him to act. Now that's the judge trying to reconcile the discrepancy, okay, in the statement made from Kimmie and then the statement made to by Henry Tenon. Interesting. Interesting that she's also not quoting the statement from Henry. She's just leaving that part out. The murder occurred days after this exchange between Fernandez and defendant. $5,000. Defendant argues Fernandez had complete control of their finances and she was unaware of his dealings with Tenon. The defense argument is incredible considering the evidence. Oof. Oof. That's strong languaging right there. The evidence establishes that the defendant experienced a short, contentious divorce from Mr. Bridegan and continued to experience issues after the divorce, mainly financial in nature. Defendant went through significant steps to protect her money from Mr. Bridegan. It is not reasonable to believe that the defendant abdicated all knowledge and control of her trust fund to her new husband. It is especially unbelievable considering how fiercely defendant fights for her children that she would leave her family's finances to the whim of Mr. Fernandez. I mean, I would go so far as to say that if all this bears out where, you know, Shanna is the mastermind, she was involved, she's found guilty, whatever, I would say that this could actually be worse than this, which is that she didn't just put the trust in Mr. Fernandez's name to keep funds away from Jared. I mean, that could have been part of it, but I mean, it's plausible, right? It's plausible that this was also planning on purpose so that when he wrote the checks, it would be tied to him and not her. Again, but that's the middleman. But that to me is what it looks like if she's involved, right? Like that could actually be even more a level of her trying to make it look like it was completely Mario because he had the control of the finances. But no one's really making that argument yet. Defendant is too financially sophisticated for this to be true. Instead, the evidence established that Fernandez was merely a conduit. Well, there you go. Merely a conduit. What does that sound like to you guys? As the trustee for the disbursement of funds that allowed her full access to her account while also shielding her wealth from her husband. The trust had language that allowed the defendant to be in control once her legal entanglements with her husband were over. This provision would not. And, you know, the thing is remember that languaging, when the legal entanglements with her husband were over, you could see that both ways. Right now, remember that languaging came from her parents, okay? Because it's they're in charge of the trust. We saw that earlier, right? Let me find that. So we're on page 7. We'll come right back to it. Let me find that part again. Here. See, check this out, guys. When our daughter, Shanna, shall have no further legal entanglements with her ex-husband, Jared Bridegan, she may elect to serve as trustee of law. So one could look at that both ways, right? What do they mean by that, right? And remember, this family trip to Hawaii, I don't know, it's interesting. I'm just saying, it's just interesting because the family trip to Hawaii, right? What happened on that trip? Because her family is very much involved with the finances, right? It's like all their money, right? And so them saying this, one could see that as like, well, guess what? When he's deceased, guess what? They don't have anymore legal entanglements. Maybe I don't know. I'm just saying. I'm just throwing it out there because not everybody understands or knows, you know, that once a person's deceased, the legal entanglements are done, right? Whether it's criminal charges or so, like, you know, you can come after somebody's estate in terms of civil, but like when he's deceased, then the child custody stuff, even legally, right? Practically, but also legally, that is over, right? Just saying. So the trust had language that allowed the defendant to be in control once her legal entanglements with her ex-husband were over. This provision would not make sense if Fernandez was truly in control of the defendant's finances. Considering this, there is no doubt that the payments from the defendant's trust were with her knowledge and consent. I don't know if you can go that far. I don't think that's been proven. The evidence showed that she knew the first 2 payments were for legitimate work, and the $5,000 payment was the down payment on her Hitman contract. She was never planning on investing in Tenon's pallet business. Admittedly, Tenon was an individual she had met in passing once. Defendant even admitted to her public relations firm that the $5,000 payment was suspicious and could be twisted against her. Yeah, I noticed that when the state said that. I was like, oh. After reviewing this evidence in this case, in the light most favorable to the state, which is the standard here, the court finds that the state has met its burden. There's ample evidence in the form of statements to Detective John's financial records and the text messages that support her guilt for the purposes of whether pretrial detention is appropriate. Accordingly, blah, blah, blah. Does not have a right to, okay, whether pretrial conditions may still be warranted. Okay. Even when the state makes the necessary showing pursuant to Arthur that a defendant does not have a constitutional right to a pretrial release, the court still has discretion to grant pretrial release under sufficient conditions. So in other words, it's not over yet. The fat lady hasn't sung, isn't that the saying? It is the defendant's burden to prove that the conditions of release can effectively protect the public from the risk of physical harm, assure her presence at trial, and assure the integrity of the judicial process. So she's got another chance. Okay, this is what I wanted to get to right here. The court is concerned that defendant is a flight risk because her ties to the community are superfluous. Defendant no longer owns her home here, does not have a job here, and her children do not live here. After the murder of her ex-husband, defendant felt so overwhelmed with the community response on social media and to the crime and her possible involvement that she left the area for 5 months without her children to escape it. Upon returning to the area, she again could not tolerate living here. To escape, she sold her home in Jacksonville and bought a new home in Washington State. Arguably, the only tie that remains to this community is a vacation home owned by another LLC connected to her parents. Defendant argues that during the investigation, she was ready and willing to turn herself in if asked by law enforcement. However, that fact does little to ease the court's legitimate concerns about the defendant's substantial connection to areas outside the court's jurisdiction. However difficult defendant may have found her life before the indictment for first-degree murder, the circumstances have only worsened. Defendant faces the possibility of the ultimate penalty. Defendant also has ample means to facilitate her fleeing, right, because of her parents' money. Yup. That's what I said. Considering these factors, the court is not confident that if the defendant were released pending trial, she would be able to resist the temptation to flee. Even if the defendant does not flee the jurisdiction. Oh, this is interesting. There is concern she may interfere with the integrity of the judicial process. Interesting. Okay, like interfering with KJ. Okay. So to like talking to the other witnesses, that type of thing. Defendant has already demonstrated that she's willing to try to circumvent monitoring of her communication, such as using other people's devices in her own, quote, burner phone. After considering the above factors, the court believes the continued pretrial detention of the defendant is necessary, and it is the only means to ensure the defendant's location is known and her communications monitored to ensure her appearance at trial and the integrity of the judicial process. So what ends up happening is they file, again, as it said, they can try again. They do try again. And that is a filing we will get to. Again, we're going chronologically, but that will be from, I think it's actually our next document. Yep, it's our next document. That's from 6/21/24. So from June, they file again for bond. So that will be our next document. As for our next hearing, hang on. We'll finish this one next time, this status hearing. So we have this, and then let me see here. So what we will have next time is we will have the status hearing, and then there's that press conference with Mr. Baez, and then there's the other motion for bond. And I'll make sure we go through these, of course, as always, in chronological order. And then we might also get to the next long hearing, the 4-hour hearing. We might get to that as well. So yeah, so we shall see. Let me see here. Hold on. Okay, let me do this. Yeah, I saw the long one. Not video file. Hold on. Didn't mean to click on that. Okay. So this is the status hearing where we will pick up with this next time. I don't know if there's anything of note. I guess I can go through it and see if there's anything of note, and if not, we might skip it. But yeah, the long one, that one is coming up as well. So it might be that on the next one, it'll be like the press conference, the long hearing, and the motion, the defendants, it's their second motion to grant bond. That will be next. And so tomorrow I have scheduled is the next Casey Anthony episode. And then on Saturday, I think is when I'm going to be doing the Daubert hearing for Karen Reed. So for anyone who's new, please feel free to check out the playlist. I have playlists for all the different trials. And yeah, I'll also get working on timestamps. I'll make this note one more time here quickly, that I always do really detailed timestamps. And YouTube is funny. Sometimes they appear in the scrolly bar, sometimes they don't. Always check the description, because if in fact their timestamps are not appearing on the scrolly bar, usually they will at some point, but you never know when. Check the description, and the timestamps will be in the description there. But hopefully, with any luck, they'll also appear on the scrolly bar, and that won't be necessary. So thanks, guys, for being here and for watching and joining us. And I'll see y'all next time.